Theory of judgment, CRP 26 of 23, Kadum Apang versus Mumang Apang.
The civil revision is allowed. The impugn order is interfered with. The learned court below will frame an additional issue on the point of res judicata, allow the parties to take evidence and then dispose of that. Okay.
Delivery of judgment item number 2, CRP 48 of 26.
And sign the revision is allowed. The petitioner is given opportunity to prosecute the appeal. They will appear before the learned court below on 7/9/2026.
Deeply obliged, man. Deeply obliged.
Go through it again and upload it.
Okay, obliged.
Any mention?
Well, I found prayer for application of one matter, item 20 matter. This last occasion also, it was due to first time not hard matter.
Okay. We'll see. Not many limited matters today.
Yes, because there's proceedings going on. I've already informed the other side also.
Oh.
Item number 1. Oh, sorry. Item number 3.
Tenants in this present petition is confined to the legality and the validity of the appellate jurisdiction assumed and exercised by the respondent number 2 and 3, who have no statutory authority to function as the intervillage territorial council.
Just a minute.
Petitioners and the respondent number 1 have disputed a plot of land, and accordingly, a kebang was conducted.
Right. They had a dispute over land. A kebang was conducted.
And a matter was decided in the petitioner's favor.
Okay.
And accordingly, the respondent number 1 filed a appeal before the civil judge senior division Pasigati. However, their appeal has been dismissed with liberty to file approach before the appropriate forum. Accordingly, they file a appeal before the intervillage territorial council.
So let us. I'm seeing your synopsis. Just a minute.
Yes.
Petition. Okay. So there was no approval for any. Now you take me to the petition.
Yes, madam. Madam, the respondent number 2 and 3, there's no authority to act as a intervillage territorial
Council.
Madam, may kindly see the article reply that furnished by the deputy commissioner.
I'll come to it. Two and three, right?
2 and
2 and 3 do not have the jurisdiction. RTI replies at
page number 112.
112.
Yes, madam. May I read, please?
What is this authority? They were inter-village council of which area?
Bogong area.
First, let me see the impugn order once. Huh? We'll come back to the RTA reply immediately. Impugn order is at page 110.
Yes, 110.
110.
And it is type transact copy.
Next hearing is fixed on 12/8.
12.
And then it will be decided ex parte. Okay, so now let's go back to the RTI. So this is the inter-village territorial council of Pasigat.
Yes.
Specifically, what is the
Bogong area.
Huh?
Bogong area of Pasigat.
Bogong area of Pasigat?
Actually, like F 112.
Where is it written? Bogong area in the impugn order?
You know,
And so and so and so and so. Might have missed. I might have missed.
here only the Pasigat was mentioned.
They have not mentioned Bogong area, but it pertains to Bogong area.
Bogong area. Pasigat is come under Bogong area.
Okay, so now the RTA reply.
Actually, like
Hmm.
112.
Mm.
Furnished by the Office of the Deputy Commissioner Pasigat.
Hmm.
But here, kindly see serial number 1. Whether any member of interviews customary court under the Bogong jurisdictions in East Siang District have been appointed by the Deputy Commissioner East Siang District after the enactment of the Arunachal Pradesh Civil Code Amendment Act 2022 as well as Assam Frontier Administration Justice Regulation Amendment Act 2023 from the year 2023 to till today. My lord,
Okay.
is no.
Hmm.
There is still that no.
Mm. Okay.
And second number, my lord. Whether any member of Apex Customary Court has been appointed by the Deputy Commissioner East Siang District after the enactment of the Arunachal Pradesh Civil Code Amendment Act as well as the Assam Frontier Administration Justice Regulation Amendment Act 2023 from year 2023 to till today. Answer also no. And 3, whether any interviews customary court or effects court has been instituted by the Deputy Commissioner East Siang District after the enactment of the Arunachal Pradesh Civil Code Act as well as the Assam Frontier Administrative Justice Amendment Act from 2023 to till date. Not constituted by the Deputy Commissioner.
So according to you, this forum does not have the jurisdiction.
Yes,
What would be the appropriate jurisdiction then?
my lord, this Interviews Territorial Council should be appointed by the Deputy Commissioners of the district.
After being appointed, it will have jurisdiction,
Yes, my lord.
but not yet appointed.
Not yet. My lord, there is a
Process.
process for consideration of the appointment of the Territorial Council.
By the DC.
My lord, the first meeting was convened by the stakeholder
By the DC.
and DC has approved the same.
Huh.
However, that approval process was stayed by this honorable court
I see.
in WPC number 187 of 2023.
You have that order.
Yes, my lord.
Page.
My lord,
Because issuing notice is not a problem since you will be seeking a stay, I
yes,
guess.
my lord.
So therefore, this aspect has to be seen.
Yes,
right?
my lord, as relevant as 159.
One- 159.
This WPC was filed by the respondent number 2 and 3 along with the others members.
Only if they're a statutory authority, they will be able to appoint
Yes.
the members,
Well, section,
the judges, so of the customary court.
yes,
So
my
that was contained in the writ petition.
yes, my
And
lord.
accordingly, there was a stay.
My lord, section 5 and section 3 of the
AFR. Anyway, so you take the steps and
Yeah.
2 weeks we stayed, heard, learned counsel for the petitioner. Full stop. The petitioner invoking the jurisdiction of this court under Article 227 of the Constitution of India has challenged the order dated 6/7/2026 passed in appeal case number 1 Roman 4 TC/03/2026 by the order was passed by respondent number 3.
yes,
Respondent number 3. And that the said respondent number 3 along with respondent number 2 are purporting to function as a inter-village territorial council customary court for the Bogong area.
yes.
Hmm.
Bogong area of Pasigat.
Bogong area. What is the spelling?
BOGONG.
BONG of the Pasigat area. Though they are not yet authorized in law to do so. Full stop. It is stated and submitted that the petitioner and the respondent number 1 had a land dispute which was adjudicated and decided by Kebang by order dated 16/5/2022, declaring the rights in favor of the petition. Full stop. The respondent number 1 challenged the same before the regular civil court, that is Court of Learned Civil Judge Senior Division, Pasigat. However, the same was disposed of on 18/12/2025 with liberty to approach the appropriate forum. Full stop. Accordingly, thereafter, the respondent number 1 preferred a proceeding before the respondent number 3. Respondent number 2. And
Later it was taken over by respondent.
whereupon the respondent number 3 passed the impugn order dated 6/7/2026, proceeding with the matter and fixing it on 12/8/2026 for hearing, failing which the matter is to be proceeded ex parte. Next paragraph. The learned counsel has contended that he submitted an RTA application which was replied to on 11/6/2026 from the office of the Deputy Commissioner Pasigat. And the learned counsel has taken the court through the said RTI reply, which is annexed as Annex 10. And the RTI reply per se indicates that no members of inter-village customary court under Bogong jurisdiction has been appointed, and no inter-village customary court or apex customary court has been constituted by the Deputy Commissioner of the district till date. Full stop. But in the meantime, there is a process.
Before that process,
No. In the meantime, the Deputy Commissioner has undertaken a process, but it is not complete. Appointment is not complete,
not complete.
but process is on.
Yes, process on. That has been stay.
Full stop. It is further submitted that subsequently a process was initiated from the Deputy Commissioner for constitution of such a customary court. However, the same was stayed by a coordinate bench of this court by order dated, what is the date of the order? Order dated 29/4/2026 in WPC 187 of 2026. Good stop. Next paragraph. The learned counsel submits that in the aforesaid circumstances, the impugn order of the respondent number 2 and 3, assuming jurisdiction in the matter, suppose from a jurisdictional error, according to you. Post. Next paragraph. The petitioner shall take steps for issuance of notice upon the respondent number, all the 3 respondents, by speed post. The petitioner is also at liberty to resort to dusty service parallel, if so advised, in which case a compliance affidavit shall be filed. Next paragraph. Upon giving my consideration to the matter, the proceedings in appeal number 110, I marked it. So and so, we had written before 14TC06 shall remain state. Proceedings in appeal number so and so before the customary court of inter-village, you write this, council, Pasighat, shall remain state. Next paragraph. As the order is being passed ex parte, needless to say that upon appearance, the respondents shall be at liberty to seek modification or variation of this. This is the matter after 2 weeks. After 2 weeks.
Item number 4.
My lordship, this is a,
It's filed by the union.
yes, CGST, Central. So, the brief fact of the case is that lordship, according to the investigating agency of the CGST,
Mhm.
they had started investigation upon this MS SRK Construction and Project Limited.
Mhm.
And after examination of their data, written filing and
A
application-
criminal investigation,
no, that's a quasi,
quasi-criminal.
yeah, quasi. So after that investigation means data, because their all data are with the central, this CGST, because in portal. So based on that, it has been revealed that they had suppressed revenue of amount 10 crore 88 lakhs 57,709 rupees in the financial year 2021, 22 and 23, 24.
Hmm.
After that, as a part of procedure of this CGST investigation, they had issued someone under section 70 of CGST, section 70. And
Pursuant to the investigation, 70 notice was issued.
yes, someone was issued under section 70. And after repeated summon, because there is a one circular, if the other party doesn't comply.
Hmm.
In page number 3 of that circular notification, if this Roman 10, page number 3, lordship.
Yes.
Yes, may I read?
Yeah.
Issuance of repeated summon without answering service of the summons must be avoided. Sometimes it may also happen that summoned person does not join investigations even after being repeatedly summoned. In such cases, after giving a reasonable opportunity, generally 3 summons at reasonable intervals, a complaint should be filed with the jurisdictional magistrate, alleging that accused has committed offense under section 172 of Indian Penal Code. Now it's a 206
Right.
of BNSS and section 174 of Indian Penal Code. That's now it's 208 of BNS. As inquiry under section 70 of CGST Act has been deemed to be as judicial proceedings within the meaning of section 193. It's a 213 in now BNSS. It's a framing of charge before the session tribal court. And section 228 of this, that's also one of the framing of charge before the magistrate court. So here within, based on this, before filing such complaint, it must be ensured that someone have adequately served upon the intended person in accordance with section 169 of CGST.
So 3 summons.
Yes,
at reasonable
4
intervals.
summons.
If they have to be properly served,
Yes,
And if thereafter he does not appear, then you can initiate a complaint proceeding.
yes, yes. Here we, department has served as with the 169. It's in CGST Act, if it's available. Otherwise, it's with me. 169 clause E.
Yeah,
Yes,
even me. Look, we have the same book, I think.
yes.
So,
CGST,
Page number.
page number 123, 123. Section 169.
Yes.
Lordship, it's there in clause C. One of clause C, 169, 1C. May I read, Lordship? By sending a communication to his email address provided at the time of registration or amended from time to time.
Hmm.
Thereby it means all those GST, those who are running the business, they register their GST number through this portal, and they submit their email ID, and credential is also submitted before this office. And through that credential and that email ID only, this service has been taken, and they can access, and through that they file return everything. So based on this, after complying all the service of this procedure, they had not appeared before the investigating agency. So that because of that delay, later on, it's very difficult for the investigating agency to frame that cognizable offense under section 169 of this 69 of the CGST and 132 of CGST. So before that date,
Complaint case was filed, but it
Before-
was dismissed by the magistrate.
yes, yes.
What's the impugn order?
Impugn order is
Against that
there
you
in-
have come, right?
yes, 68, page number 68. Page number 68.
A detailed order. No, it starts from,
Page 68 till long order.
it starts from page 64, I guess. It starts from page 64.
This impugn order is there in page 68. Complaint start from there.
Okay, let us read, we'll read from 68.
Yes.
Oh. Hmm.
May I? The instant case is taken up for,
No, 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 68.
yes, 68.
We are not on the same page. It starts, the instant. Other page number is different. No? The instant case is taken up for trial.
Yes,
Like that.
yes, yes,
It's-
yes.
It's in page 64.
Okay, yeah. 64.
Go ahead.
The instant case is taken up for trial and disposal on being endorsed by Learned Chief Judicial Magistrate Capital Complex with order dated 29/12/2025. Complainants Union of India is represented by Learned Counsel Mr. This. Perusal of the record reveals that the instant complaint case has been filed under the provision of section 223 BNSS with the prayer for taking cognizance of offense under section 206, 208. Operatively, these two sections will be attracted away in this complaint. BNS 2023 against accused person SRK Construction and Project Limited and Sitapalli Lalit Sanjeeva Reddy. Learned counsel for complainant submits that accused number 1 is a company registered under the Companies Act and having its registered office at this number is the director of accused number 2, accused number 1 SRK Construction and Project Private Limited Distance. It is further submitted by Learned Counsel for the complainant that in the month of May 2025, while making an inquiry into a GST related matter, it was found that accused number 1 has not declared their tax liabilities totaling an amount of rupees 10 crore 88 lakhs 57,709 in GSR 1, and the same has not been paid by accused number 1 through GSR 3B written during the financial year 2021 to 22 till 2023 to 24 by deliberately suppressing material facts with intent to evade tax amount of rupees 10 crore It is further submitted by learned counsel for the complainant that upon finding the above, a summon dated 29/05/2025. This is the first summon date, was issued to accused number 2 under section 70 of Central Goods and Services Act 2017 with the direction to appear either in person or through an authorized person on 30/05/2025 at 11 a.m. at the office of Commissioner CGST and CX, Itanagar Commissionerate, Naharlagan, Arunachal Pradesh, to give evidence, produce necessary documents or things which were under his possession or in control, and to depose verbally and in writing. However, we,
I've gone through, let us read from here. Land
yes,
Council.
last,
Let us read from page 70. You come to page 70, third paragraph. It is further seen.
yes,
Because the law is just reproduced, the sections are reproduced. So 3 summons were issued to him.
yes, yes.
So it is further seen. You can read from here.
It is further seen upon perusal of the plaint that complainant on the first instant issued summon on the accused person on 29 with direction to appear on 30/05/2025, whereas the accused person by admission of the complaint in the plaint reside at Hyderabad. It is further seen from the plaint that as per the reply dated 29/05/2025, the accused person sought time till 20/06/2025. On the grounds of prior and pre-scheduled official commitment, similarly, a second summon notice was issued dated 30/05/2025 with a direction dated 30/05/2025 to appear in person or through an authorized person on 06/06/2025 in the office of complainant to give evidence, produce necessary documents or things under his possession, and subsequently due to non-appearance by the accused person. A third summon notice was issued dated 08/06/2025 directing the accused to appear in person or through an authorized person on 20/06/2025. By their own admission in the plan, accused person was represented by one Mangalpuri Pani Chandra.
I get it.
Yes.
On the first day, this, of course, this was rightly held by the magistrate. This was, the time was too short, 29 and next day appearance for someone who's staying in Hyderabad, right? That's so he could not appear. Short time till 20th June, right? And thereafter on 30th, on the next day, another was issued to appear on 6th. This is okay. 30th May to 6th June, yes, person can come from Hyderabad, no problem. So, and subsequently due to, but there was no appearance on the second day.
Yes,
And then third, notice was issued on 8/6
yes,
to appear on 26,
yes.
20th June. On that day, on the third, with regard to the third summons, on 20th June, this Deputy General Manager appeared.
Yes.
So the magistrate held that it was not a case of absconding. And therefore it was rejected.
Lordship,
Plaint was dismissed.
yes, Lordship, actually, they run business over here in the state of Arunachal Pradesh. They generate revenue from here. So their office is over here somewhere.
We issue
At-
notice at this stage.
Okay.
Issue notice.
Yes,
Because there's nothing to stay.
Yes, yes, yes.
We'll issue
Nothing-
notice. We'll examine. I'm
Yes,
not
yes,
disputing
definitely,
it
Lord.
at this stage.
Yes,
But we'll examine the correctness or otherwise of
yes, yes, Lordship.
magistrate. It's a case of dismissal of complaints.
Yes, because of this only, we cannot proceed further proceeding. Because until unless they appear, the data with them, that cannot be examined. Because B2B, those written, those detailed hard copy will be with them.
Heard your CG's
Yes, yeah, senior standing counsel for the CGSA.
learned counsel for the petitioner, Union of India, GST and Customs, within bracket GST. The petitioner has invoked the inherent powers of this court under section 528 BNSS, assailing the order dated 27/1/2026 passed by learned JMFC, Hopumpare UPA in CR case number 140 of 2025 under section so and so. Full stop. Next paragraph. The projected facts in brief at this stage is that during an inquiry by the CGST department, the respondent firm was was found to have suppressed tax liabilities of 10 crore 88 lakhs 57,709 for the financial years 21-22 and 21-22 to 23-24. Full stop. It is stated that repeated summons were used, being summons dated 29/5/25, 35, 8/6 and 18/7, but the respondent failed to appear. On this ground, seeking to invoke the appropriate penal provisions under the BNS, the complaint petition was filed, leading to registration of the aforementioned CR case, which however came to be dismissed. Dismissed by the learned magistrate on the ground that the ingredients thereof are not available and that it was not a case of deliberately evading summons or notice from a public authority or servant. Right? Issue notice upon the respondents. How will you take steps? Speed post.
One is a speed post, one is through their portal, because they access this portal,
The
169 of this BR.
steps may be taken by speed post as well as to the electron. That is permissible.
Yes, permission, 169 of CGST, that provision is there.
Also through the electronic portal under section 169 of the
CGST Act.
CGST Act. List after 2 weeks.
4 weeks.
3 weeks.
3 weeks. Highly available.
Matter number 5.
Mayor Lordship. Lordship, Lordship, we are before this honorable court, Lordship, for setting aside the impugn order dated 2/4 of 2026, whereby the learned judicial magistrate class has taken cognizance in CR matter, that is
Check bouncing.
check bouncing case. Lordship, in very nutshell, Lordship, what has happened in the check which was given, that was a check that was dishonored on 1/5 of 2025.
Mhm.
Again, the legal notice was sent on 2/5 of 2025. And it was delivered on 13/3 of 2025.
Mm.
But after more than a year, Lordship, this
Complaint has been filed.
complaint has been filed. And that is the impugn order, this Lordship, that is in page 42.
Just a minute. And yes, so it is 1 month, 15 days, 30 days.
Lordship, it says after delivery of the
30
legal
days.
demand notice, after 15 days, the course of action arose, and within the 30 days.
Within 30 days.
Within
That's why I said
Yeah.
1 month, 15 days, 30 days.
Yeah, Lordship. But here in Lordship, in our case, the
That is 142,
142 sub clause B.
you wanted me to see the impugn order at page
14, Lordship.
14. No, negotiated. Sorry.
That is an order of impugn order 2/4 of 2026. As Lordship, I have shown this honorable court, Lordship,
Didn't the magistrate notice this aspect? That it's, huh?
From the order, Lordship, it seems that.
When was it filed? Endorsed by?
That Lordship, from the order, it's the case
Cognizance of offenses on so and so, it's by initial deposition. Yeah.
May I read, Lordship? It says
Yes, sir. No problem. This 142.
section 142 subclause B, Lordship. May I read, Lordship? 142 subclause B.
Yes.
One cognizance of an offense. One subclause B says, Lord, such complaint is made within 1 month of the date on which the cause of action arises under subclause C of the proviso to section 138. Yeah,
Now let us see 138C.
138,
We know these things, but still we should refresh.
138C. 138C. 138C.
Within 15 days.
It says, C says, the drawer of such checks failed to make the payment of the said amount of the money to the pay, or as the case may be, to the holder in due course of the check within 15 days of receipt of the said notice. So case in our hand before this honorable court, Lordship, in their Lordship, I have annexed their complaint petition in which they have.
That means within 1 month of the date of receipt of notice.
Yes, Lord.
We can say it like that.
Complaint petition, Lordship, I have annexed in my annexure 1, that is 1 series, right from page 16 till it's in page affidavit till 24, Lordship. In the page,
Page?
it starts from page 16 to page 25. Lordship, the operative portion will be page 21, that is paragraph 9. In that, this is the complaint petition before the learned trial magistrate, Lordship. Lord Mayor return. The 9 Lordship, what this they have made in the stated that the cause of the action of the
Now, this is, you have reproduced the complaint petition.
yes, Lordship. In the petition
Is the complaint petition annexed?
annex, Lordship. I have annexed, that is the annexer 1 charge. And in my
Annexer. Oh, I see.
Yeah.
I thought you had. So he has himself stated,
yes,
right?
Lordship, in that paragraph 9, Lordship.
Legal notice was delivered on 13/5.
Yes, Lordship. The cause of action of the present complaint has arose on 28/5 of 2025 on account of legal notice delivered on 13/5 of 2025. Lordship, counting from 13/5 of 2025.
For 13/6, calculating 1 month is very
1
easy.
month.
No, from 35, from 13/5 he gets 15 days.
Yes, no.
From 13/5 he gets 15 days.
No, Lordship, it says from 13/5 you get 15 days. So it will
So
start
that will be 28,
28 or 29, Lordship.
28 or 29, something like that. So it has to be filed within 29 June, say,
Yes, Lordship.
29 June. Why it was filed on?
That Lordship, the order is, Lordship, coming to paragraph 11 also, again, in the same Lordship, in the, what they have stated before the complaint also. The complaint was filed, the complainant was filed a complaint before this honorable court on 21/5 of 2025 by complaint number so and so. That is the same party. It was dismissed by this honorable court on ground of complaint for premature stage. Meaning that they had all, before this, they had filed an
Earlier complaint which was dismissed as premature.
premature. Apart from that,
Because you can file a complaint only after
15 days.
yeah, the cause of action arises on the date of receipt of notice.
Yes, Lord.
And your right to file the complaint arises after
After 15
after 1 month of
One.
that. After 1 month of that. So it was dismissed
On
So and so.
premature.
on premature. And thereafter what happened apart from that?
Apart from that, no, that Lordship, they have not mentioned anything in there.
Okay. So this complaint only was cognizance was taken,
Yes,
earlier one.
earlier. So this lordship, that the impugn order, we have seen it's in 12/4 of 2024. That is in
This
page.
may not be very correct, actually, anyway. The earlier complaint was dismissed, he has to
Dis-
file a fresh complaint, I guess.
Yes, lordship. In his lordship, he has not made.
2426. That's long time after.
Yes, long after. And
Anyway. Heard Mr. So-and-so,
vision.
the learned counsel for the petitioner. The instant application has been filed under 528 BNSS assailing order dated 2/4/2026 passed by learned JMFC UPIA, taking cognizance with regard to taking cognizance in complaint case number 40 of 26 under section 138 of the NI Act. Full stop. The learned counsel has taken the court through para 9 of the complaint, which is annexed as Annexer 1 series in this petition. The same may be reproduced here in below. 21, page 21, you reproduce. Full stop. In the context of the same, the learned counsel submits that the complaint case in terms of section 142D,
B lordship.
142(1)(b) has to be filed within a month of receipt of notice. And therefore, within 28/6/2025. Full stop. Next paragraph. Referring to paragraph 11, it is submitted that the complainant had filed a complaint on 21/5/2000. Is the complaint number same?
No, lordship is different.
It's different.
39 of 2025.
The being CR number 39 of 25, which was dismissed on as being premature. Full stop. In next paragraph, in this context, the learned counsel submits that the order dated 2/4/2026 passed. Even if he has filed a subsequent complaint, it has to be
Within the,
I don't know if they have filed anything, but there won't be so much delay between.
yes, lordship. that-
Suppose they had filed on 28,
Yeah.
suppose the 28/5. A complaint filed on 28/5. Will the cognizance be taken in 2/4/26?
No, lordship. then-
It doesn't, it's not in the ordinary course of things. Anyway, let us see, let them come and make their, we'll get the records,
Yes, lord.
scan records. What they say, Major? Sit down. That's. Passed by the learned magistrate in CR number 40 of 2026 is clearly time barred in terms of the statutory provisions. Next paragraph. Issue notice upon the respondent by speed.
Yeah.
Call for the scan TCR of CR number 40 of 2026. Should we call for the earlier one also?
Earlier
Good.
will not be necessary, lordship.
No, let us, I know, have a, what happened, transpired exactly, as well as CR number 39 of 2023. That will be helpful, I think. Full stop. Next paragraph. Upon perusing the materials at this stage, I am persuaded to pass an interim order till the returnable date. Accordingly, till the returnable date, the further proceedings in CR 40 of 26 shall remain stay. List after 3 weeks
Bibliography.
or 2 weeks.
Lordship, since the record will be necessary, 3 weeks.
3 weeks will be there.
Bibliography.
Item number 6.
Yes, sir.
Yeah.
But I'll do it for you. What is the subject
Now,
matter?
the imperial order which I have challenged is in page 86 Annex 3. Now, this is a PCS case number 7, 2025, in SICPS case number 03 of 2021. Now, there was an inquiry. After inquiry, on the basis of the inquiry, a case was registered and charge sheet was submitted. When the charge sheet was submitted, there were three accused. One is Inyo Nakar, present petitioner, Ojing Nakar, jail also, and Tamio Taga, this is Deputy Commissioner Pachigat. Tamio Tata. On the basis of the charge sheet, there was a hearing for framing of charges against the accused. The imperial order, which I have challenged, is in page 86, dated on 16/7/2026. The operative part of the order is in page 90. Accordingly, charged under section 408, 409, 420, read section 120B of IPC and section 13(2) of PCS are framed against accused person, namely Ojing Nakar and Enyo Nakar. However, accused Tamio Tata is discharged from present charges are read over and explained to the accused person, to which they have pleaded not guilty and claim to be trapped. Now, next day speaks on 4th December 2026 for appearance of accused person and for passing and on such. This is the impugn order. Then, prior to that, the court has taken the cognizance, and cognizance order is in
No, charge is framed.
charge in frame.
So the case is at the stage of trial.
And I have come against the framing of the charges.
Okay.
Now, my question is that what is the allegation against me? Allegation against me is only one thing, that
Let us see the charge sheet.
such,
You can see the charge sheet. He is on bail, I guess. He's on bail.
yes,
Ah.
he's on bail. Now,
Okay, so
my lord,
charge sheet, you must have annexed the charge sheet, right?
my lord, here I have in the para 11 of my petition,
Okay.
I have mentioned that the content of the charge sheet is more than 2,000 pages.
2,000 pages.
More than 2,000 pages.
Oh, that's not possible to annex.
Not possible to annex entirety of the pages. So,
Para 11.
para 11, I have mentioned it in my petition.
Okay, that's fine.
Now, entirety of the charge sheet, what I have gone through, and entirety of the inquiry report, which I have gone through, there I have not found dishonest intent and fraudulent intent. Nothing. There is no ingredient of all the sections which charges made against the accused part, against the petitioner. My status is, I was the director of land management, government of financial project. Whatever reports, orders, and comes from the sea, My duty is to forward it to the secretary and commissioner for approval, in particularly in this case. What was the amount? What was the sanction amount? I do not. And it was not handed over to me.
I have to read the,
Then would that
to appreciate your submission.
the money, can the 409 be attracted against me? And 420, whom I have cheated? And 468, this is forgery.
We can read the impugn order. I'll go through the impugn order first. Huh?
Impugn order.
Yes. I'll go through it, sir. I'll go through it. So about the land valuation, basically, that they manipulated the land valuation. That is the basic allegation.
No,
Basic
that is not manipulation. But
That is the allegation.
now my contention is that
Mm.
there will be any omission and commission. But all the omission and commission will during the file process, they cannot attract the final offense. They will come under administrative lapse. When it is to be converted into a criminal, all the ingredients of section are to be attracted against that person. But whereas not a single section which they have filed against the accused is not attracted here in the case.
Okay.
Now, a person now, normally, a file process, during a file process, may also attract criminal offense if intentionally they violate the statutory provision. But second, if they violate the mandatory provisions, whereas here in the search and that search, there is no questions of the violations of statutory provision, no violations of the mandatory provisions. Even in the third sheet, they say that whatever amount we have put up before the commissioner, it was not false. It was not false. It was forwarded from Pasigat DC office to Director Land Management. But only it was not put with the typing. But there is a chamber discussion. Will the matter work?
Anyway, we'll examine.
Yes, ma'am.
Mm,
At this stage, my lord,
No, I want to complete that in the search it what exactly it is also content and what inquiry they have during inquiry they have
Hmm.
found.
Okay.
They only I have put up, I have inserted where I have inserted
Hmm.
and what is the source? Source is that it was forwarded from
Hmm.
DC office Pasigat.
He insert, I mean, the rate from Jonai,
You know,
No, my lord,
I'll come to you. Was it?
it was
Come to-
collected
Mm,
from Jonai
Hmm.
by the dealer. So.
mm,
And later on, it has come to know that it was an in-process
mm,
file. But it was not known to me
mm.
on good faith. And the in-process file, the enclosure was not sent to me. So how I'll know? If it is an in-process file, why it was forwarded to me by the deputy commissioner?
Okay.
And what is the excuse? He was authorized to collect by the board members. There was a sitting of board member. And whatever he has collected, it was forwarded to me. It is not a false document. And even in the third field also, they have clearly reflected that it is not a false document. In the page 67, they have clearly said, for the concern office of the Assam government, in process document was not a false document. It is not a false document. It was collected from Jonai, and the who has collected, he was authorized person. I simply the director. This document was forwarded from DC office Pasigat. So I have inserted it when the file was in process as per dictation of the commissioner.
Hmm.
In December.
Hmm.
So what offense I have committed? I have not committed any offense. And in the entertainment circuit, there is no dishonest intent. There is no fraudulent intent. Therefore, all those sections are not attracted at all against the present petitioner, and the charge has been framed against him wrongly.
We'll examine that definitely. Okay. Should I come to you?
yes, ma'am. My lord, here, my lord,
How will you get the charge sheet?
Shashi, ma'am, the scan copy.
Scan copy.
The scan copy will be confirmed.
I'll have to see the scan copy.
Yes, my lord.
But do one thing. Tell them to make it searchable, or you have to make it searchable here. Because
But it has to go.
through the,
Yes.
yeah. Searchable scan copy.
Right.
Right. That will be, because such a, you have to search.
That can be given.
I can give it. It's not a difficult thing to make it searchable.
Yes.
Yes, please, make your submission.
My lord, if my lord turns to page 56, my lord, of the charge sheet. What was the fault of this present petitioner? 56, my lord.
Hmm.
My lord, in fact, the senior counsel is very true in saying, on submitting that the rates were, forwarded from DLR so Pasigat, approved by the committee members and the deputy commissioner, my lord.
Hmm.
But he being the then director, my lord,
Hmm.
he forwarded it to the secretary, my lord, the deputy secretary,
Hmm.
and to the chief secretary, and the chief secretary marked it to the chief minister, my lord.
Hmm.
And there were non-existing rates, my lord.
Hmm.
And it was approved, my lord. When the file came back, my lord, what he did, he inserted serial number 10 and 11 by his own hand. That was rupees 11 lakhs.
That is the bone of contention.
Yes,
This rate,
This is, my lord.
allegedly he was interested in
Yes,
this.
my lord.
land.
11 lakhs 91,700
700.
per biga, my lord.
Hmm.
But the existing rate, which
What?
government, the chief minister approved,
Was,
was from hardly from 300 to 800, my lord.
Huh?
800.
That much difference.
My lord. I see
no,
this-
can't be that much difference.
Yes, my lord. Oh,
Huh?
my lord. Rupees 20 to rupees 800. Which, my lord, we find at page number 54, my lord.
The 9 categories rate varied from 800, 54, my lord, 1, 2, 3, 4, 5. Fifth para, my lord. The 9 categories
Got it.
varies from 800 industrial per square meter to a minimum of rupees 20 rupees per square.
That much difference.
Yeah, that is what is the case, my lord. And it was inserted after the the Honorable Chief Minister has approved the file.
Approve the rate of 800.
Yes, my lord.
Anyway, we'll examine.
The 9 categories, my
We'll
lord.
examine.
And we have inserted 11 lakhs, my lord, almost 12 lakhs, my lord. And therefore, my lord, the total amount of the cost was almost 106.7 crores, my lord, or almost 107 crores, my lord. Due to this rate, my lord, since it was inserted, my lord, and the money was already in the LRSO and Deputy Commissioner's account, my lord, and without the permission of the Secretary, my lord, that was dispersed to 50 beneficiaries, my lord. And therefore, my lord, 76 crores just was disbursed, my lord. And due to the lack of funds, my lord, the project could not be completed, my lord, in time. That was the reason.
Heard.
My lord, what do you, I am in the case. Deputy Commissioner, after approval of the rate, before dispersing, as per the notification, that he should take again approval from the government for disbursement. So he has violated. In spite of that, he has been discharged. So I am seeking the penalty.
We'll need the material.
Official information of the one person, one accused. They have stated is an official lapses of the administrative lapses. But in my case, they have framed the charge. So I am seeking the penalty here in the petition.
The heard senior counsel, yes. Anything?
No, my lord, whatever. At this stage, my lord, the scan copy of the is not
Yeah.
called for.
Scan copy and the other scan copy can come physically.
Yes,
The case diary, how voluminous is the case diary?
More than 2,000,
the charge sheet has only 5, my lord,
More-
4, my lord, then
more than 2,000.
the evidence has started.
And we will not sublet in paper. We will sublet only in the community.
Heard learned senior
Huh?
counsel and part. Assisted by,
Yeah.
your good name, please. Assisted by the petitioner is invoking the provisions of section 528 BNSS agreed by order dated 16/7/2026 passed by the learned session judge, learned special judge Apumpari UPA in SIC.PS case which will be the case number? Okay. SIC.PS case number 03 of 2021.
7 of 2025. In case number 03 of 2021.
Yes, that's the case number. Let's stop. Arising out of PCA case number 7 of 2025, whereby in para 11 of the same said order, charges under section 468, 409, 420, 120B IPC, read with section 13 within bracket 2 of the Prevention PC Act 1988 were framed against the present petitioner and another accused, Ojing Nankar. However, third accused, Tomio Taka, was discharged from the present case. The learned senior counsel submits that the order framing charge is erroneous and the acts attributed to the petitioner would at best call for administrative action, but it does not constitute a criminal offense. This further submitted that the accused who was discharged was on a similar footing with the petitioners or with the present petitioner, and therefore the present petitioner also ought to have been discharged. On the other hand, the learned special PP, right, SCB, submits that the case diary and charge sheet runs into 2,000 pages. Is voluminous in nature, running into 2,000 pages.
More than 2,000.
And it is submitted that for the acquisition of the land, a rate ranging from rupees 20 to rupees 800 was approved by the government under the signature of the Honorable Chief Minister, but the rate which was finalized at the behest of the petitioners was rupees 11,91,700. And that on the basis of the same rupees 82 crores, more than rupees 82
Like
crores,
67.
67 crores have already been discharged, disbursed. The next paragraph. I've given my consideration to the matter, full stop. Issue notice upon the, only one,
There are two respondents.
you can represent two.
Well,
Stop. The extra copies be furnished to the learned special people. The respond number 2 being police official can be represented by
My
the
lord.
special people. Full
My
stop.
lord.
Call for searchable scan copy of the case diary of the case record comprising case diary, charge sheet, and any other relevant documents.
My lord.
Full stop. It is further directed that during the pendency of this petition, the criminal trial may not be disposed of.
My lord.
My lord, I'm going. Please take a extra copy.
I have received.
It may not be disposed of. He's on bail already.
But then the trial will go on, my lord.
Trial can go on.
My lord. Deputy apply.
May not be disposed of. Well, trial can go on. It may not be disposed of during the pendency of this criminal petition.
Matter number 7.
Yes, please.
Your Honor, this is an application for watching and setting aside under section 528 of BNSS. So based on, Your Honor, based on mutual settlement made by the joint petitioners in connection to Nijuli PS case number 72/20,
Who is the FIR?
Lordship,
FIR
FIR is page number 25.
35,
25.
25. The allegations per se are serious, isn't it? Robbery at a SBI CSP. Anyway, then what happened? No, nobody was named in FIR. Huh? Chukot was CSP owner. Where is the agreement?
The agreement is page number
Case was registered under which sections?
390.
392,
Robbery.
544 IPC. Agreement.
64 to 66. Agreement.
Mm.
Your Honor, the brief fact of the case is that the offense has not arisen out of any serious offenses like mental depravity or murder, rape, dacoity like that. It has arisen out of mere misunderstanding, business rivalry, frustration, and commercial, financial, etc. And moreover, Your Lordship, the parties are distant relatives and they have resorted to mutual agreement. And the petition number 1 has also showed his unwillingness to pursue the matter further. And Your Lordship, if you see, the offenses are crime in persona, not in crime in rem. So, Your Lordship, if these accused petitioners from 2, 3, 4, and 5, so they will be suffering irreparable loss and cannot be compensated later if this honorable court does not interfere and set aside and quash the further proceedings of the criminal proceedings, which is pending
Okay.
for the.
Yes, Ms. Jini.
I have a small issue, Your Lordship. If Your Lordship will come to page number 64, that is the mutual
I'm on
settlement.
64 only.
Yes, Your Lordship will see the accused number 4, Tar Tango, son of Tar Bayu. Now, if Your Lordship will come to page number 28, Your Lordship. 28 is the part of the charge sheet, Your Lordship.
28.
Yes, Your Lordship. Your Lordship will see accused number 3 is Tar Tango. Father's name is Tar Tajik. Completely different to what the agreement, father of the agreement is, Your Lordship. The same will also will find, Your Lordship will find at page number 33. 31, deep pleasure, 31. It is
Okay.
31, Your Lordship will see. In the first paragraph, third line, Sri Tar Tango, 23 years, son of Sri Tar Tajik, Your
Yes.
Lordship. This agreement does not reflect the name of the details provided in the mutual settlement, and
Mm.
the rest of the records of the court are,
There's a discrepancy with
Yes.
regard to this person.
yes, Your Lordship. Now they have come only under this mutual settlement, Your Lordship.
Yes.
Such
To get this
discrepancies,
clarified then.
or else they can withdraw and file a proper settlement, mutual settlement with the corrected details, Your Lordship.
Leave it to them.
Mhm.
We can,
However,
uh.
the fact remains the same that page number 31, and the same person which the learned PP was
No, but the
stating,
father's
that's a-
name is quite different.
Uh,
Tar Tajik. I mean, is he also known as something like that? You need to educe. Or you take an instruction.
Mm.
I'm facing it on any date as per your convenience next week.
you can
Right.
correct it.
Then you take the instructions. Okay. So that court has pointed out this. So kindly clarify. Good stop. Heard, so learned counsel, an additional bit. The learned counsel seeks to take an instruction regarding one issue pointed out by the learned additional PP regarding the father's name of one third Tango, who along with 3 others had entered into a written agreement dated 11/5/2026 with the informant by way of settlement of the case. Prayer is allowed. When should I fix it? How much time would you need? Next Friday?
Next.
Take a week, no problem. He's on bail, right? No problem.
Yes, of course. However, it's not submission. Then in these circumstances, the further proceedings may be set aside.
No, let us first get the feedback.
Because it is fixed on 10th of this month.
Doesn't matter.
It's only for appearance. I think it's
Only
only
for
for appearance.
You're on bail, so no issues. You will not be prejudiced. Next Friday,
Next Friday. Much of that.
you have some 1 week time, so let's take the date. Next Friday will be 14.
Item number 8 to 10.
Lordship, this has been pending for last 2 years. I am for this. This item number 8 is Lordship, where they had challenged this criminal complaint number 1, criminal complaint number 87. This in criminal petition number 188 of 2024.
All the
I'm for the respondent, Lordship.
okay. You're for the respondent, you're for the petitioner, in all 3.
Yes, my lord, but I'm appearing on behalf of G Banerjee, my lord.
G?
G Banerjee.
Okay,
He was supposed to come, but due to ill health, my
from
lord.
Gauhati.
Yes.
Otherwise, should we keep it at admission or send it to hearing? Since you said it is ready for hearing.
Yes.
24 matter, it will come up. Even if it is for hearing, here there is no problem, as I have always said. Hearing will not delay the matter.
Just here, Lordship, only thing is that there is no stay in this one.
There's no.
188. And for regarding this item number 9 and 10, criminal petition 02/2025.
They're all connected.
Nine, here the GST
Yes,
are the main party, madam. 10 and 11 here.
Yes,
it is
state.
main party.
yes,
Here, madam, they challenge the FIR.
yes,
All the records are here.
yes, Lordship.
Then you work out a mutually agreeable date. You work it out. If necessary, you can give the date later,
Yes, ma'am.
after talking.
Yeah.
Learned counsel, you good name?
80 ma'am.
A. Timu makes a mention on behalf of Mr. J. Banerjee, the leading counsel, submitting that he was supposed to appear in this matter today but could not come due to some health issue. Full stop. He is appearing for the petitioner in all the three matters.
Yes, madam.
Okay. Full stop. Learned counsel, you're in respondent in all three.
Yes, all three cases, but
Private respondent.
in criminal petition number, item number 8, 9 and 10,
Hmm.
the respondent number 1 and 2, they state.
Oh, there's no private respondent.
Private, the CGST,
Oh,
3 to 7. 3 to 7, I'm representing.
in learned counsel, 3 to 7.
Standing, no.
There is no state.
And additional PP, Mr. Atif, for the state. Full stop. The records,
Yes.
scan records are available. Full stop.
My lord, in many occasions, my lord, they have sought for adjournment, my lord. So for that reason, my lord, the CD original we have received, so we have sent it back. Now at this stage, we don't know whether it has been charge sheeted or not, my lord.
Hmm.
Because the investigation was not started, my lord. Only there is a direction, there no coercive action against the.
Next paragraph. The original case diary was earlier received. It is submitted by the Mr. Atif, learned additional PP that
EB.
on earlier occasion, the original case diary was received, but it was sent back. And he has to take instructions as to whether the investigation is completed and oblique or whether any charge sheet has been submitted. The prosecution will take the necessary instructions. Should we admit and fix it for hearing?
Yes,
my lord.
yes, on 29.
In the meantime, the matter is stated to be ready for hearing and therefore the criminal petitions are admitted. Instead. The prosecution shall procure the original case diary,
Maybe
procure,
it's can, my lord.
scan copy of the case diary and charge sheet, up to date case diary and charge sheet. Please submit.
Yes.
List on
29, 9, madam.
29.
September, my lord.
Both the learned councils mutually suggest the date of 29 September. It's fixed on.
Deeply
Okay,
obliged, my lord.
then do it and finish it.
Yes, my lord. Deeply obliged.
Item number 11,
May I please, your lordship? Lordship, this application jointly filed by the petitioners, lordship, on the basis of
No.
settlement, lordship. Before your lordship come to the FIR, lordship, the fact is that, lordship, the petitioner number 1 and petitioner number 2, they are in relationship, lordship. And the petitioner number 2, who is already married a person, lordship, he hid a fact that he is already married, lordship. Later on, when the matter, she learned about the marital status, lordship,
Mm.
then there was a fight and altercation between the both of them, lordship.
FIR, let us
FIR, lordship.
page.
Lordship, page 19, lordship.
Yes, please.
Yeah.
Page 19.
May I, sir? Yes. The officer in charge, Papuville Station, FIR against Miss Manning, but he, veteran so and so, attempt to murder, previous hurt, previous injury, attack from dangerous person, and also try to burn alive at touching politics. That is the petitioner number 1. With due respect and understand, I would like to request you to register an FIR against Miss Manning Bucky for attempt to murder, attack from dangerous weapon and plan to burn me alive at Pachipal. That's where I have been attacked at around 8 a.m. at NS and C rented apartment. That is the rented apartment of the petitioner number 1 herself. Near August store, the allied accused found petrol and light fire to me and tried to burn allied inside the bathroom when I was changing my clothes. That's where I was helpless and was given no chance to save myself from lighting petrol fire upon my body. Due to the incident, I got burned seriously all over my body, heavily damaged over my ligament and private parts. As of now, I'm currently admitted at Fifth Hospital, Nagaland. This is the FIR lordship filed on 7/5/2024. After 2 months of medical treatment, he has been already recovered from all the
But he suffered serious injuries. it
serious
seems.
injuries, lordship. No doubt, lordship. But the fact is that, lordship, after when the petitioner number one, she learned that she has come to know that the petitioner person is already married person, lordship. She wanted to end up the relationship with him, lordship. But despite the fact that, lordship, the petitioner number two insisting on her to maintain that relationship, lordship. And there was, in fact, lordship, the petrol which she thrown or as the allegation contained in the FIR, lordship. The real fact is, lordship, she poured the petrol from her scooty, lordship, and tried to burn herself alive, lordship. That is the fact, lordship.
Herself
Yes, lordship. Out of frustration
to commit suicide.
commit suicide. In the meantime, lordship, the
I want to read the narration in the charge sheet. Should I read it or you'll read it out? From page 25. Because this case is of a slightly serious nature.
serious nature, but the,
Agreement is there, then we'll come to the agreement.
yes, sir.
Or if you want, we can first go to the agreement, then we'll come back to the charge sheet.
Okay.
If you want, whatever you prefer. We'll see the agreement first.
Yes, lordship.
Okay.
Because the agreement, it has,
That's you're seeking. Otherwise, no issues. If it was a simple hurt or something, absolutely no issues. But whether it will violate any of the parameters laid down, right? As you know too well. Anyway,
the language and the intention of the parties, lordship, is already clearly revealed in the agreement itself, lordship.
let us read the agreement. If it's not long.
The agreement starts from page number 34.
You read the original only.
That the
Yanning Paki.
first party is the petitioner number one. The second party, Hilangraj, is the petitioner.
Oh, she is also joined as a petitioner in this
Yes,
petition.
is jointly filed by both of them. Whereas, lordship, Mayor, lordship. Whereas the party were in relationship since April 2023, lordship. Second party reiterated to marry the first party. Subsequently, the first party came to know that the second party is already a married person. This lead to misunderstanding in between them. This misunderstanding escalated to such an extent that first party caused burn injuries with petrol to the second party, leading to the lodging of an FIR dated 2024, which was registered at Prohibitions station under section 236, 226 of Indian Code against the first party on the complaint of the second party. Whereas the party have mutually agreed to settle their dispute amicably and wish to record the terms and conditions of their settlement in the presence of respective family member and witnesses. Date of agreement is also, lordship, very important, lordship. The date of agreement is 30 July 2024. And you note the date of agreement. Now, therefore, in consideration of mutual promises and covenants contained herein, the both party as follows. Both party express regret for any inconvenience caused to each other. The second point, the first party shall refrain from asserting any claim that the second party is her husband, from entering into any form of relationship with him, from interfering in the marital life of the second party. Additionally, the first party shall not repeat the offense as allied in the FIR. In the event of breach of this clause, the penalty or fees regulated shall be imposed on her and her family member and vice versa. The medical expenses incurred for the treatment of the first party shall be borne by herself, by his first party himself. No claim of reimbursement shall be made in the future effective. Both parties have amicably resolved their dispute and expenses, and there are no outstanding between them and agree to withdraw all the allegations made against the other in connection with this matter. The second party agrees to not to pursue any criminal proceeding against the first party in relation to the subject matter of aforementioned FIR and vice versa. The city so and so shall be granted as any of them. This agreement intended to voluntarily without any caution. Now, lordship, though the allegation made in the FIR is serious in nature, I'm fairly agree to that. But the fact which lead to file that FIR, lordship, that is very important.
That's whatever, the brief. Let us read the FIR charge sheet now. See, yes, the page 25. Quickly we go through.
Yeah.
Or should I go through it myself first? I can go through it myself also. Okay. He suffered 44% burn injuries. Therefore, to street 26 has been given.
Like also, if your lawsuit has already perished with tacit also, the escalation took place because of a different two parties lawsuit. Even she herself tried to take the lawsuit after lighting up the lighter lamp. In fact, she has also sustained some injuries. She was taking a treatment at Hema Hospital lawsuit. After looking up the FIR lawsuit, they didn't even try to run lawsuit. She accepted that yes, there was incident took place in the at the hospital.
What do you say, Jim?
Now the case is pending before the judicial branch.
At the stage of
At the stage of appearance also.
appearance.
And now what's it the judgment laid down by the Honorable Supreme Court in the Lakshmi Narayan lawsuit. The ratio laid down in that judgment lawsuit, which clearly covers this matter also.
Grievous offense, will it cover grievous offenses?
Previous offense lawsuit, especially special act.
Grievous hurt, third degree burns. No, let us see these judgments again, Narinder Singh and Lakshmi,
Lakshmi Narayan.
you have the. I would like you to assist the court, as possible. What is your take on it? Otherwise, there's no issues on the settlement, but the thing is that
Your Lordship.
Yeah.
If I may, Your Lordship. Your Lordship, first of all, Your Lordship, I have seen the, at page number 33 is the MLC report, Your Lordship.
33.
33, Your Lordship.
Hmm.
32, Your Lordship will see mixed type of burn is 2 to 3rd degree burn, Your Lordship, which is very serious in nature, Your Lordship. Your Lordship will see the remarks. How serious was the injury of the victim, Your Lordship. Patient given emergency treatment at EMT trims, admitted, burn, 2 plastic dialysis later referred to higher center Gauhati by surgery department. At the time of the report, injury report preparation, patient admitted in ICU of the Gauhati as per the report of the patient's party, Your Lordship. Now, the claim made by the one of the petitioner herein is that she had tried to commit suicide, and while he had tried to take the petrol gain, he got his injury. If I may take Your Lordship to the statement of the other petitioner at page number 21, Your Lordship.
Page
21, Your Lordship. This is the statement given under 161 before the investigation officer, Your Lordship. 20.
by
The second paragraph, Your Lordship. After knowing his marital status, I decided to leave him my life and requested him several times to left me alone, but he never heard of and insist of that. He began to give me mental and physical harassment on routine basis. Likewise, on 6 May 2024 at 5:30 am, we had a spate of argument at rental house Pachin Colony, Naharlagan, and he had mercilessly beaten me with the help of lethal weapon, and later he had walked out, so I took out about half liter of the petrol from my scooty in order to burn myself. Meanwhile, Sri Hilang Raja came back suddenly at home and snatched the petrol. Now, if Your Lordship directly come to page number 22, Your Lordship, since it was contradictory to the statement made by the complainant, Your Lordship will see the question put up. Where is the petrol bottle and lighter? The lighter is hidden in the dustbin in the room, and the petrol bottle thrown in the the river from Pachin Colony hanging bridge. She had such a time to go to the hanging bridge and get the bottle disposed of. Can you show me so and so hidden bottle? I can show the place where I hidden the lighter and petrol. Now, Your Lordship will see the claim made that it was when he tried to snatch the bottle. If I may take Your Lordship then to page number 20, which is the statement of the accused.
page
Page 20, Your Lordship.
20.
Page 20.
Hmm.
I'll start with the 6th line, Your Lordship. I have been attacked today, 7/9/24 at around so and so at NS rented apartment Popular near so and so Pachin Colony. The alleged accused, my girlfriend, namely so and so, daughter of so and so, village so and so, who is presently sitting in a relationship with me in my rented room, has thrown petrol and light with fire to me and tried to burn alive inside the bathroom, Your Lordship. The place of occurrence is inside the bathroom.
Okay.
So as per this submission made that there was a misunderstanding, is not totally misleading, Your Lordship. Now, Your Lordship will then find the judgment of the Daksa Behan, Your Lordship. I haven't produced it, Your Lordship. But the Daksa Behan, in the case of
He had
Daksa
to
Behan,
undergo plastic surgery also.
yes, in this and Your Lordship will also see the punishment for the offense under 326 is
Life.
life imprisonment.
Up to life.
Yes, after life imprisonment.
Not easily.
Yes.
Usually it's not imposed, but
I'll
it's
just-
up to life.
I'll just submit the citation through the court master, Your Lordship. This is Daksa Behan versus State of Gujarat, Your Lordship, where this apex court has clearly stated that heinous or serious crime, which are not private in nature, which are not in private in nature and have a serious impact on society, cannot be quashed on the basis of compromise, Your Lordship. In this kind of
This
cases,
is of which year?
this is Daksa Behan is of 2022, Your Lordship. I'll just pass over the
After Lakshmi.
after Lakshmi, and even the Daksa Behan
What
was
is the
more
spelling? Daksha.
DAXA
DAXA.
DAXA
Ben. BAN.
N versus State of Gujarat and
Gujarat.
others. Yeah. The citation, Your Lordship, is
I'll look at it.
yes, Your Lordship.
You can send it.
Even in this matter, Your Lordship, the court was dealing with the attempt to suicide, Your Lordship.
Hmm.
And the argument was also made therein that it was not a, it was totally, abatement of suicide was totally a private nature, of private nature. The court has disagreed to that and stated that such kind of serious offenses are not public, private in nature, and in fact, it has an impact on the society, Your Lordship. Even in this case, Your Lordship will see the injuries are very grievous. If it was even of a case of a husband and wife, that would have been totally different case, Your Lordship. The agreement does
Even
not.
then, spouse also do not have right to burn each other.
I completely agree to that.
Burn each
I
other.
completely agree. But still,
but-
then, if they were married together, that would have been a very totally different cases, Your Lordship.
With children.
And yes, and also the submission being made that she was tortured, and later on she came to know about his marital status. There is always a
See, the
she
thing
always
is that,
had
but the thing is that the principle is something like this, if I've understood correctly, there is that the moment, even in the most serious of cases, suppose which cannot be quashed, suppose a murder, suppose the main witnesses, suppose that will be illegal agreement.
yes,
Suppose they come at an agreement, and then the prosecution case, the prospects of the prosecution case would be very badly affected, even in the most serious case.
Yes.
But that does not mean that you exercise the inherent powers
it
to
has,
quash it.
yes,
It may fail in trial, but just assuming that it will, since they have agreed, it will fail in trial.
absolutely not.
And the case being very serious,
Yes,
should the inherent powers be exercised? You
There
get
is
am I
very-
being able to make
yes,
clear what I'm
yes.
trying to say?
yes, Your Lordship.
So that is the dilemma actually. Yes, they have arrived at a settlement. They want to move on in life, but that is also there. But thing is that a person suffered serious
Yes.
injuries, with serious, fulfilling the ingredients of 326.
Yes.
So in that context, whether it will be justified to exercise, whether it will violate these guidelines, the LCD's decision, examen.
Yes. Or also, Your Lordship will see that there are ample of evidence against the one of the petitioner here in Your Lordship. It's not that when the matter will be tried in the trial court, that the case would there would be any
It is, no, the circumstances are tragic, no doubt. She herself tried to end her life.
yes.
The circumstances
That
are
is her
tragic.
treatment, Your Lordship.
Tragic, yes. But the thing is that whatever it is, from a point of view of public law,
Yes. It's a serious crime.
the dilemma comes about whether to quash or not.
Even to the statement that she had tried to commit suicide has to be
Mm.
proved in the trial, Your Lordship.
Well, like a small reminder, what?
Right.
The judgment relied by this style, and when Daksha Behl also, since that judgment I have not gone through that. But in the present case also, the fact and circumstances are very important. How the FIR has been made process.
I understand.
And in fact, also the petitioner, while they were in a relationship also, she herself was subjected to a mental and physical problem.
That's why I said the entire circumstances are tragic.
Yes, Lordship. And Lordship, so far as the judgment rendered by the Honorable Supreme Court in Lakshmi Narayan.
If it was the ordinary kind of injury, some assault, something, then unhesitatingly we could have said, even prosecution would have agreed that yes, let them move on.
Yes.
But here,
And this just
it assumes a element of public interest because of the serious injury inflicted in the
No.
unfortunate incident.
no one no one is above the law, Your Lordship. There are
Nobody asks
there,
also.
yes,
All of us.
any issues there is always a protection given under the law, Your Lordship. That has to be approached instead of
In Dexaben, the other decisions have been discussed.
yes, Lakshmi Narayan has been
Just take it out, no?
I have just
You
I
take
have
it out.
just sent it to Santosh.
Take it out. I'm keeping it for chamber.
Yes, yes, yes.
If I'm, should be able to complete. If I'm unable to complete, I'll reserve it.
Yes,
Because then I'll have to take the file.
yes. I have just
I'm
given
going
it.
tomorrow, so, but I'll try to complete it today only. Subject to time constraint. Vishwabandhu, you have submitted, right? This, no, this one. Vishwabandhu. You have submitted this one?
No, Vishwa Bandhu was submitted on the earlier occasion by my colleague here.
Okay, from the prosecution side, I'll write it.
Lakshmi Narayan Lordship, the specifically the paragraph Lordship.
Para?
Yes, sir. I have put the flag mark on that.
Okay.
The
Hmm.
paragraph Lordship,
Narinder Singh. They have reproduced from Narinder Singh. Narinder Singh is actually the main judgment
yes, Lordship.
on cautioning person to settlement.
Yes.
This law has been developed in subsequent decisions.
Even in that's a pen that
Hmm.
was taken.
Page
you know,
number, yeah, para 29.4 Lordship. So specifically, I'm relying on this issue.
So para?
Para 29.4.
Okay. Let us read that then. On the other hand, those criminal
Trivial cases having overwhelming means predominantly within character law, particularly those arising out of commercial transaction, arising out of matrimonial relationship or family dispute.
you are trying to this. And will this be can this be called out of matrimonial disputes?
Yes, sir.
Can you-
Exactly, Lord.
No, no, Your Lordship.
No, the dispute arose out of relationship, but the consequences were quite horrific.
Yes,
No?
Lordship.
In that sense, it may be, may not be also. We have to think. Matrimonial, family disputes, of course, clear. Matrimonial disputes will be something like, say,
In fact, Lordship, if the petitioner.
divorce petitions, 498A, all these things are going on.
Yes, the very definition of wife is
And
more
also the
particularly was
date-
decided in domestic violence case by the apex court, Your Lordship. And even for the maintenance part, Your Lordship, live-in relationship was considered for maintenance, Your Lordship. But not in this case, this kind of cases that this relationship would amount to a matrimonial case.
After the registration of the FIR Lordship, the petitioner number 2, he fully recovered from the hospital Lordship. He realized it mistake also Lordship. There was a mediation between two family members Lordship.
That's okay.
Your Lordship, reserving the judgment.
Not reserving. I'll try to, because I need to go through that judgment
Yes,
also.
I've just.
I will write in the chamber. If I am unable to complete due to time constraint, then I will take the file. Then it will be resolved.
No.
I will inform you. That's why I'm not dictating the order now. Huh? Okay. Just take a short break. I'll come back.
Item number 12.
May it please your lordship. My lord, here, my lord, on last occasion, CD was called for, my lord, but we have received a WT message that the investigation has been culminated into, my lord, charge sheet. And charge sheet has been filed, my lord, in this case.
All right.
And moreover, my lord, the notice upon the respondent, perhaps the steps has not been taken properly by them, my lord.
Steps has not been taken. Okay, please take the steps. Okay, please take the steps. It is mentioned here. Full stop. The learned additional PP submits that as for information received, investigation is completed and has resulted in a charge sheet by CS number
14 of 26.
14 of dated.
2/7/26.
Full stop. Full stop. As per office note dated 6/8/26, the steps upon respond number 2 not yet taken. Full stop. The petitioner shall take steps upon the respond number 2 as per the prescribed procedure through the registry and to be executed through the concerned police station.
Through PP, my lord, through the office of PP.
Through the office of the PP.
Yes, ma'am.
To be executed through the concerned police station. And whereafter the prosecution shall take instructions regarding service. Full stop. In the meantime, call for the scan PCR of, we'll call for Chongkham PS case number 10 of 26.
Yes, ma'am.
Comprising case diary and charge sheet.
Yes, ma'am.
Yes, from the court of the learned special judge.
Also.
Hmm?
Also, my lord,
This will
especially,
be which district?
my lord,
Namsai. It's in Namsai district.
Namsai district.
The judicial authority would be they're from the concerned learned court.
Yes, ma'am.
Write it like that.
We'll verify it, my lord.
Okay. List after.
On special Teju, my lord, it's special judge Pokso, Teju, Lohit district.
Sure, no?
Yes, ma'am. It's written in their bail or earlier bail rejection order, madam.
Special, so earlier rejected,
Yeah, by the special court, my lord.
okay, then so. Special Judge Poksho,
Teju,
Lohit District at Teju.
Yes, madam. Obliged, madam.
List after a week,
After a week, madam.
after a week, we can fix it on. Let's give a date then. 18?
18, yes, madam. 18.
18.
Yes, okay.
Okay.
Matter number 13.
Wait, please, hello.
Yes.
Also, this is a bail implication. On the earlier occasion, the city was called upon.
Mhm.
Also, the accused was arrested on dated.
Motorcycle matter.
Yes. Yes. The section which has been added is section 30523. Yes, so this is a theft. It prescribes a punishment of 7 years. And
The motorcycle has been recovered,
Not recovered, madam.
not recovered.
Not recovered.
Serious receipt.
CD received, my lord. Yesterday it was listed. Today, my lord, we have somehow we have obtained the case.
Oh, sorry. It was fixed. When it was fixed? Last?
My lord,
4.
yes, my lord. Yesterday itself, my lord. The matter was
Oh, I see. Yes,
yesterday. My lord.
yes. Okay. I remember now. No problem. No.
But I just, without wasting any time, let's I like to come on the grounds for my bail.
Mhm.
What's my humble ground, which I want to bring into consideration, is a medical ground.
Mhm.
So my son is aged about 3 years old, namely Jonathan, who is suffering from a chronic epilepsy. Also, this is a comprehensive seizure in the neurological system, which comes in every time interest. And prior to my arrest, before the 4th July, my son, who is a minor child, was before the medical surveillance under GNRC Gauhati. It is a specialized neurological hospital. But this is my humble submission is that, my lord, why I am entitled to be on bail under the discretion of this honorable court is that my child has to be given a proper medical treatment. And if not given today, my lord, it will be non-curable in the near future. I have annexed all the medical documents, both from the state as well as from the JNRC of Gauhati. A proper medical certificate had also been furnished from the doctor. That is from page number 29. Annexure B series. This is one of my ground. My primary ground is the medical ground. And secondly, I just want to read the medical ground if Lordship will allow. This is a certificate furnished from GNRC Hospital, page number 29.
Okay.
To whom it may be concerned, please be advised that Master General Tayam is a case of generalized epilepsy. Since 20
General epilepsy, yes. General epilepsy.
and the rest are the medical documents.
6/7/26.
Last treatment was called upon in the month of June.
This was procured after his arrest, right? I think so.
Yes.
After his arrest.
My second humble ground.
This is before arrest. This one is before arrest. 2026. He's having treatment, no doubt. This is after. These are 25. Second ground is?
Lordship, I was arrested on the 4th July,
Hmm.
26, and subsequently I have been behind the bar for more than 30 days. Today is 34 days. Lordship. Now, after my arrest, there was rigorous 3 days of police remand, in which all the necessary interrogation upon me has been conducted, and after the completion of the remand, I was sent to the judicial custody. Upon my completion, Lordship,
the investigation agency had neither paid for the extended police remand also. And it's not that I was not cooperating. In my capacity, whatever I could, in the manner in which I can cooperate with the investigation, I had done it. And because of me, only 2 co-accused names had also been revealed. So this, Lordship, at this stage, my custody in the judicial custody may not be required. This is what I humbly pray. Because had it not been the case, Lordship, still they would have prayed for the extended police custody remand. But also, right after 3 days, I was sent to the judicial custody.
They have not prayed.
Yes,
They
Lordship.
have not prayed.
Which also means the investigation on my part has reached to an advanced stage.
Hmm.
So other accusers are on their part, investigation may be conducted, but on my part particularly, it has been completed.
Hmm.
Now, Lordship, my third humble ground is that this matter was heard for 2 times.
Hmm.
Once in one occasion, 16 July, 26 before the learned Gauhati, and another one on 27 July. For the earlier occasion, Lordship, I have highlighted my grievances in the manner how I am agreed by the order passed by the learned district and sessions court. There are numerous clerical errors.
Well, that's okay.
Yes, but I have no objection.
I remember.
But only I want to bring in the
Uh-uh.
application. So I am seeking for some extension of benefit. Lordship, my subsequent ground is there, the final ground, Lordship. Lordship, I am a person, citizen of ICR only. It's not that I am from outside. So whenever my custody is required before the honorable trial court or before the police station, I'm ready to cooperate. In fact, my house, own residence is nearby the police station office. I'm just one call out. If my custody is where anything has to be, investigation has to be done on my part, I will appear before the court. I undertake before this honorable court.
Okay. Then that. Yes. We come to it.
Your Lordship, before
Yeah.
coming to the merit, my lord, on this regarding the length of detention part, my lord. Now, my lord, it is well settled that earlier, my lord, it was settled that for the purpose of investigation, police custody, my lord, the entire period of investigation will be taken as a whole. At any time, my lord, can be sent to judicial remand and taken back to police remand as of
For
the-
460 on the BNSS.
Yes, madam, 187. Now, my lord, it has been extended in 90 days offense,
No,
where investigation period is for 90
this
days.
is
Within
for-
6,
this is 60 days of it.
now, my lord, 90 days. Why? Because I will bring it to light of this honorable court, my lord. The other sections are also inserted, new sections.
Okay.
During the course of investigation.
Then for 90 days offense, person
60
taken into account.
60 days within,
Up to 6, within.
up to 60 days, my lord. JC to PC, PC to JC can be done, my lord.
But, yeah, but he has to be in custody, no?
Yes, my lord. Absolutely, my lord. So that is permissible, my lord. That law is settled, my lord. That no need to be reiterated because so far as, my lord, if suppose the police has kept it for 3 days, later on he found that the other materials there for which, my lord, his police custody is required, then again he can be taken into the police custody. Now, my lord, coming to the merit of this case, my lord, and so far as, my lord, second part, my lord, the medical regarding ground on medical ground is concerned, my lord, that aspect has already been settled in Darshan matter, my lord. Until or unless the disease or the ailment is of life taking disease, my lord, the court cannot go into that aspect, my lord. And for that also, my lord, an absolute bail cannot be granted. Only to the extent that for treatment purpose, my lord, the court can extend interim protection. And now, my lord, let us come to the merit of this case, my lord. Here, my lord, it seems to be theft initially, my lord, but, my lord, this case involved a, my lord, vehicle theft racket, my lord. Here, my lord, this other section which has been inserted and inserted by intimating to the concerned magistrate was, my lord, section 61(2), that is criminal conspiracy. 112 subsection 2, that is, my lord, the petty organized crime. 317 is, my lord, is procuring purchasing the stolen property despite knowing that is a stolen property.
New sections have been added.
Added, my lord. And as part, my lord, it's a and it's permissible also during the course of investigation.
The order of the magistrate.
Yes, my lord. Order, perhaps, my lord, to my humble understanding, it is also settled that order is not required, but intimation to the concerned court, my lord. That intimation has already been given, my lord, and this is the application also, the part of the case diary. And now, my lord, Here, my lord, this person is not only involved in this this is not only the case where he is involved, my lord. My lord will find in the disclosure which they have made in their application, in other case, also, my lord, the same offense he has committed. My lord will find in paragraph 6, my lord. He is a habitual offender and his perhaps, my lord, his source is this, my lord, the theft and, my lord, this vehicle racket, my lord. And it's well organized, my lord. My lord will find in para 6, my lord. That the applicant submit that the applicant has no criminal antecedent other than the one mentioned above, that is ITA PS case number 78 of 2026.
The current case, EWS is 78, this one.
No, my lord. 90, current case is, my lord, 90, this is,
So this is another,
this is another one, my lord.
in which he was arrested.
Earlier, in that case, he was arrested. In 97-26, my lord, the FR was filed because that person was not being able to trace out by the investigation authority. But during the course of the investigation in this ITA PS 78 of 26, he has been identified in the CCTV footage. And basing on that, my lord, the
PS 78 of 26 is also pertaining to vehicle theft.
yes, my lord. My lord will find in the page number, my lord, may kindly come to page number 42, my lord. Here, he has been granted bail, my lord. He has been granted bail. Perhaps these new things were not placed before the court, my lord. I'm not on that because that is a different case. But, my lord, that has to be, antecedent has to be taken into consideration by this honorable court, my lord. My lord, may kindly come to page number 42, my lord.
But looking at it from another point of view, he has there's some force in his contention that he has been custodially examined and they subsequently never
No, my lord.
not sought his.
Why, my lord? Why, my lord? If it is only pertains to the theft of one motor vehicle, my lord, then, my lord, some leniency may have been shown by this honorable court. My lord, he is involving in a theft of multiple, my lord, vehicle, and his, my lord, the modus operandi will always also been revealed from the case diary. My lord, may kindly peruse the status report also. He is not only the person who is involved in the case. Other accused are also involved. He, my lord, he commit the theft, and he, my lord, supply the vehicle to other person for 5,000 rupees, my lord. And then further they sold it to other person. It's a networking, my lord. And now at this stage, my lord, to break down this, my lord, the chain, my lord, his custody is indispensable because two other accuser, my lord, one of the accuser is still at large, my lord, and the vehicle are still not recovered, my lord. Because, my lord, this vehicle are procured by the hard-earned money of the public, my lord, from the society, my lord. And he is stealing all this vehicle and selling it for, my lord, to earning money, my lord, in illegal way, my lord. My lord, may kindly peruse this, my lord, in status report, everything has been given, and the person involved in this offense, my lord. Here in this case, my lord, this is an organized crime, and, my lord, one of the offenses, my lord, punishable is up to life, my lord. For that, my lord, the investigatory period would be 90 days, my lord.
Lordship, if I may submit for a while.
Yeah.
I have not even submitted even a word for the merits of the case. Because the guidelines are there not to conduct a mini trial, but now I will submit.
No, not a question of conducting mini trial. I mean, the huge racket.
Yes, my lord, that is what, my lord, I'm submitting, my lord. It seems to be very simple, my lord.
Assam, Nagaland,
All over, my lord, Northeast. So he's released, my lord, and
the huge racket suspected to be in.
yes, my lord, and my lord, to unearth, my lord, even to apprehend the other, to break this chain, my lord. At this stage, his custody is indispensable because, my lord, the statutory period is 90 days. Because, my lord, other sections are also inserted, my lord, in this case. And other person are also found to be involved in this case. And the antecedent so far is concerned, my lord, is in the petition, my lord. He is also involved in the same offense, my lord. So today also, if he is released, there is also an apprehension that again he will be involved in committing the same offense, my lord.
This right. Yeah. Yeah. Sum up your submissions quickly.
Yes, Lordship. Lordship, I was arrested not upon this case. I was arrested on dated 4th July for another case.
On 5th July.
Yes, PS 7826,
Hmm.
in which if we see, Lordship, in my position, it might be there in the city, only one scooter was found. And that scooter was given by another person to whom I have given the name in the police station, but however, they have not proceeded with the apprehensions. Now, be that as it may, I have highlighted my grievances. Now, when I was arrested, I was in the custody, Lordship. The IO, present IO, had registered another case in my head against me. Now, on that very case, that's why I have annexed it on the page number 42. That is the particular case I was in there. Now, in that case, I have already been enlarged on bail. And in my, if Lordship will just give a pedantic approach with a judicious mind, in my possession, only one scooter was found. And more to that, about the CCTV footage of the Royal Enfield, my lord, during the statement, when the statement was recorded in police station, if inside the police station, Lordship, if the IO is closing the door, pulling out all the articles to be used for the 3rd degree, even the most holy person will admit this fact. That's why section 161 has remained inadmissible. This is the case, and all the possession and everything is an allegation. Now that's why, Lordship, I am not submitting anything on the merits. In my position, only one scooter was found, and as of now, my humble submission is that, Lordship, I am not going anywhere. I am cooperating with the investigation agency. I am ready to appear before the honorable court. And about all the investigation has to be conducted about the other accused. On my part, all the investigation has been completed. The matter has already reached.
No, that's that's not for you to say. I mean, the IO is the master of the situation as far as investigation is concerned. He has written his report anyway. I mean, of course, you have a right to say that probably the investigation is completed.
Lordship, any stringent terms and condition there, I will comply.
Please write. We already written in the last order. Para 1, 2, 3, 4, 5. Up to 5, same. Full stop. The next paragraph. The scanned case diary has been received. Full stop. The learned counsel for the petitioner submits that the minor son of his minor son is a patient of general epilepsy, due to which he is undergoing treatment, including at Gauhati, and therefore he is also required to accompany and assist in the treatment of his son. Full stop. It is submitted that after his arrest, he was custodially examined for 3 days in police remand, and thereafter the investigating agency has not sought for further police remand. Full stop. The learned counsel also submits that multiple bikes were not recovered from his possession in any manner, and that he is aggrieved by the order of bail rejection passed by the learned session judge, which also contains certain errors. Full stop. On the other hand, the learned additional PP, Mr. Ate, submits the scanned case diary which has come along with a status report prepared by the IO. Opposing the bill petition, the prosecution submits that in the meantime, additional sections, penal provisions have been added, including those pertaining to conspiracy and petty organized crime, etc. And that now the applicable statutory period will be 90 days. It is submitted on the basis of the status report and the case diary that the investigation has provided leads revealing a wide network involved in stealing motorcycles and selling them in Arunachal Pradesh and Assam and other places. Full stop. Based on the leads, some persons have already been arrested from Nagaon district of Assam, and some other persons are also being tried to be apprehended as materials regarding their involvement in the racket have been found. Referring to the relevant provision of BNSS, the prosecution submits that that it is permissible now to seek police remand if necessary for during the period up to 60 days in case of such offenses. Full stop. It is stated by the IO in the status report that the primary case property being the motorcycle is yet to be recovered. And investigation is at a crucial stage during which communication and technical and financial links are also being explored. Stop. The IO stated that due respect has to be given to personal liberty, but the bail at this stage may not be granted in the interest of investigation. Full stop. I have considered the submissions of the learned counsels on both the sides and peruse the relevant portions of the case diary, including the detailed status report. Considering the projected contentions and the projected circumstances of the investigating agency, full stop. I agree with the contention that it may not be prudent to grant bail at this stage. According, the bail petition stands rejected at this stage. Return the case there.
Deeply obliged.
Item number 14.
My lord, item number 14 and 15 is related.
Same.
Same. And item number 15 maybe take up first.
Well, it has come up for orders. Why? For
Let's see. Earlier, Dusty was allowed. Dusty completed, and in compliance of that, I have also filed affidavit. So today,
there are 28 petitioners,
yes,
28 respondents.
yes,
Just a minute.
Dusty was allowed. Dusty has been completed in compliance. Affidavit also filed, my lord.
I'll come.
Now I'm pressing for interim. Yeah, my lord.
Just a minute. You kindly go through, read out your synopsis. Let us read the synopsis together.
My item 15 or
Yeah, 15.
the present civil revision petition under Article 220 of the Constitution India is directed against the order dated 10/4/2026 passed by the learned civil judge, senior division, Pasighat in civil appeal number 2, whereby the learned appellate court has stayed, suspended the operation of the order dated 0902/2026 passed by the learned civil judge, Junior Division, Pangin, in misapplication number 02 of 26, entitled to number 11 of 2026, disposed. Your Honor, may I,
You read completely.
the dispute arises out of the election process of the Adi Student Union, governed by the bylaws of its parent body, Adi Vanakava, as well as bylaws and constitution of the Adishu. As per the rotation system, the post of president for the session 2025 to 2028 was required to be allotted to CME district. However, the same was allotted to Namtai district, leading to intervention by the ABK TRO, resolution number 7, dated 14/11/2025. The said resolution was challenged by the former president by filing title suit 11 of 2025, wherein an interim order dated 20, my lord, it should have 28/11/2025 was passed, directing that the election process be deferred. Despite the subsistence of said order, the election process carried forward, and candidates were declared elected unopposed on 24/1/2026 and 25/1/2026. Proceeding under order 39 Rule 2 CPC, formulation of the said order was presently pending. Thereafter, the learned trial court by order dated 9/2/2026 passed in miss case number 226, filed under order 39 Rule 2A, read with 151 CPC 1908, suspended state the effect and operation of the qualified candidate list dated 25.
You are not the newly elected candidate.
No, no,
Other ones.
no.
Other ones.
I am the representative of the COME district. I am not concerned with the newly elected or
Concerned.
elected by the ABK. My concern is my district was supposed to be allotted president. However, it was not allotted.
When was the dusty service made?
Dusty service was on May 30. They are not turning up.
So significant time is
30, I have already served. They
30
received.
May.
Yes.
So,
It's been almost 3 months.
Yeah.
My lord, the gist of the case is the respondent herein have filed a title suit. Thereafter, without making me as a party, obtained an interim order in favor of them. After coming into notice of the interim order, I filed an IA and
for vacating the same.
yes, modification vacation. Then the learned junior division was pleased to modify. Up to that, the election process should not be conducted till the disposal of.
But it was still conducted.
Yeah, they issue circular postponing the election. Thereafter, again they file appeal. When appeal was not entertained, they file revision. When revision was not entertained, they withdraw both. Thereafter, they conducted the election and then redo the title suit. Before withdrawal of the title suit, I filed already misapplication for violation. So my main contention is the election itself is the election itself was conducted in violation of the interim order. So the election itself is void. Therefore, their election should be suspended. It was suspended by the learned junior division, but in appeal, the senior division has again
Against the suspension, the appeal was filed.
yes
And the appellate court
stayed the suspension order of the junior division. Now I'm against the
that
order of the senior division. So, Your Honor, with regard to anything done in violation of the court's order is void. I have a
can I see that order passed by the junior division?
senior division is at page number
And this civil revision,
213.
this civil revision is also same
That is against the withdrawal.
against the
Withdrawal of their title suit. 11, the earlier initial title suit.
okay.
They after violation conducting election, thereafter they went and withdrew their title suit with a motive to just escape the violation proceedings. So I am challenging that also in 28.
That was allowed to be withdrawn.
Yes,
Allowed to be withdrawn.
we allowed to be withdrawn. I am challenging that. When there is a violation application pending, the matter is in session of the court. In spite of the he allowed the withdrawal. The order 2212 is
Take
at
some time then anyway.
239 to 247, page number 239. This order, my lord, has not been challenged till then. In fact, earlier 239
239.
and excerpt 7.
Exertion.
In fact, earlier the injury
Junior
was in
division.
favor of them.
Oh.
Here, the interim was modified, deferring the election. May I read, my lord?
Just Yes.
But it's a long order. The operative person is at phase 246.
Hmm.
Last point number C.
Hmm.
The 8th interim injunction
Where? 246.
246 C. The 8th interim injunction granted earlier is extended and modified to the extent that the entire election.
And the interim order was passed, then they appeared to vacate it.
Yes, earlier without, in our absence, they
Ex parte.
obtained ex parte. We came and we filed an IA for modification. Thereafter, after hearing both the side,
It
this
was
was
modified on these lines.
Yes,
On this
election
line.
process was stayed.
Okay, so to the extent that the entire election process scheduled to commence shall remain deferred until further orders of the court.
Yes. In spite of this, they gone with the election and declared the result. So, my lord, anything done in violation of court order is void. With regard to this, I have a citation.
And the appeal was filed against this order.
Yeah, actually, against this order,
They filed an appeal.
no appeal was filed.
No appeal.
Only appeal was filed against the stay of the order, earlier order 0902 order. But this order has not been challenged till date. Without vacating or approach the junior division for vacation or alteration, they have conducted thereafter. Now they are actually they are holding a fruit of a poisonous tree. At paragraph 8, my lord, page number.
This is a Supreme Court. It's not a Supreme Court decision.
Page number.
Anyway, whatever it is. Which High Court? This one?
This is of
Calcutta. It is.
Calcutta High Court.
Page?
Page 2, paragraph 8. May I read, my lord? The opposite party, contender number 1, appears to have transferred the disputed property to the opposite party number 2 and on for so and so in willful and deliberate violations of the aforesaid injunction order of this court dated so and so, which was then very much in force. The former had no right to transfer the disputed property to the earlier in violation of the aforesaid injunction order. No title could thus pass by the said transfer dated by the opposite party so and so. So and so during the subsistence of the said injunction order dated so and so. The opposite party number 2 could neither have acquired any title to the disputed property by virtue of the purchase under the relevant deed of conveyance dated so and so. As such, it would be pertinent in this context to refer to the decision of the Chancery Division in Clerk versus so and so, so and so, so and so, wherein it was held that an act done in willful disobedience of the injunction or court order is not only a contempt of court, but also an illegal and invalid act, which could not therefore affect any change in the rights and liabilities of the others. So also held by the Supreme Court in so and so, holding that an order of injunction or an order for preservation of status quo cannot be circumvented by the parties with impunity who advantage in derogation to the rights of the parties who were litigating originally. That being so, the transfer so and so. My lord, whether the contemptor should be allowed to retain or enjoy proof of his contempt. For this also, Reliance, Delhi Development Authority,
That's a famous case.
Whether the contemptor should be allowed to retain or enjoy proof of his contempt. The question at page number 8. Last part, my lord, page number 8.
Para?
My lord, is para, continuation of para.
I'll find out.
Continuation of para 9. Continuation of para 9 at phase number 8.
Long paragraph.
Last line.
Para 9, yes.
Yes.
The continuation of para 9.
Yes. At phase 8.
Mhm.
The contemnor should not be allowed to enjoy or retain the fruits of
Wait,
his
wait,
contempt. This is the question. The last line, last line.
last line.
Yes, single line. Thereafter, next page,
No, no, I'm getting
page 8, my lord.
page 8.
Yes.
Okay. Mhm.
Last line, the contemnor should not be allowed to enjoy or retain the fruit of his contempt.
Hmm.
The principle that a contemptor ought not to be permitted to enjoy or keep the fruits of his contempt is well settled. In so and so, this court had clearly held that undergoing the punishment for contempt does not mean that the court is not entitled to give appropriate directions for the remedying and rectifying the things done in violation of its order. The petitioner herein, this is a factual. Thereafter, my lord, next para. The above principle has been applied even in the case of violation of order of injunction issued by civil court in so and so, so and so, so and so. I need not cite authority for the proposition that it is of high importance that the orders of the court should be obeyed. Willful disobedience to an order of the court is punishable as a contempt of court, and I feel no doubt that such disobedience may properly be described as being illegal. If by such disobedience the persons enjoined claim that they have validly affected some charge in the rights and liabilities of the others, I cannot see why it should be said that although that they are liable to be penalties for contempt of court for doing what they did, nevertheless, those acts were validly done. Of course, if an act is done, it is not undone merely by pointing out that it was done in breach in law. If a meeting is held in breach of an injunction, it cannot be said that the meeting has not been held. But the legal consequence of what has been done in breach of the law may plainly be very much affected by the illegality. It seems to me on principle that those who defy a provision ought not to be able to claim that the fruit of their defense are good and not tainted by the illegality that produced before them. Thereafter, my lord, to the same effect are the decisions of the Madras and Calcutta High Court in Century Pro Limited but so and so, so and so, so and so. In Century Mill Limited, it was held by a full bench of the Madras High Court that where an act is done in violation of the order of stay or injunction, it is the duty of the court as a policy to set the wrong right and not allow the perpetuation of the wrongdoing. The inherent power of the court, it was held, is not only available in such cases, but it is bound to be exercised it to undo the wrong in the interest of justice. There was a case where a meeting was held contrary to the order of the injunction. The court refused to recognize that the holding of the meeting is a legal one. It put back the parties in the same position as stood immediately prior to the service of the interim order. And next paragraph, my lord. In Surajpal, a division bench of the so and so has taken the view there the defendant forcibly disposes the plaintiff in violation of the order of injunction and took possession of property. The court directed restoration of possession to the plaintiff with the aid of police. The court observed that no technicality can prevent the court from doing justice in exercise of its inherent powers. It held that the object of Rule 2A of the Order 39 will be fulfilled only where such mandatory direction is given for the restoration of possession to the aggrieved party. This was necessary, it observed, to prevent the abuse of process of law. There is no doubt that this statutory law has to be applied and give effect to by this court if necessary by overruling any procedural or other technical objections. My lord, thereafter, these petitioner from the beginning, they were not came before the court with clean hands. In the initial original title suit also, they did not inform the court that their tenure is over. Thereafter, in the appeal also, they didn't inform about the court of the pending proceeding in High Court and other appeals. Therefore, on clean hands doctrine.
This is Manipur High Court.
Yes. Oh, personal security. उसमें झंडा.
This is Manipur High Court judgment is on what subject? It's on
Yes, on my lord, on clean hands.
Oh, okay, sir.
Personal, ganda one. My lord, at page number 22, 22 and 21. Page number 22 and 21. Hmm. Hmm. My lord, at page 21, 10, paragraph 9, then 10. In KD Sharma sale, the court held that.
Where,
Page
page
21,
21, para,
para 10.
para 10, where is para 10?
No, I think
Oh,
ninth,
yeah, got it.
ninth point number.
This is inside, no?
Yes.
We can resume after at 2
Yes,
o'clock.
madam. My lord, since there is paucity of time and my
No,
lord is
no,
leaving,
no problem. Yeah,
so my
okay.
lord, I'll only locate,
I've understood the matter broadly, you know.
my lord,
but,
I'll only locate the paragraph, and I have also submitted my written argument, gist of the fact and my grounds. So my lord, first on clean hands,
Okay.
Mutum Siam Kesho Singh case, at page 20, inside 7.
Which case?
Mutum
Oh, so this is Manipur case.
at page 20, paragraph 7. I'll only locate my lord since there's paucity of time.
No, sorry. Page 20,
Page 20,
para
side 7.
Yeah, we were reading that. In Prestige Lights.
Yes,
Ah.
and thereafter, my lord, next page, inside 10. In KD Sharma. This is on clean hands. Thereafter, my lord, another on clean hands is latest judgment 2025, Auroville Foundation case. Is at paragraph 9 and 10. Paragraph 9 and 10 on clean hands. Thereafter, my lord, I have also submitted 3 another case. Lord, that is one is Sodu, Bhatti, and another case. That is on, my lord, any act done in prohibition of the court order in void and known as indirect law. It's at paragraph 12, 13, and 15 at phase 3. Paragraph 12, 13, and 15. Sonu Bhatti case.
It may not be necessary to discuss everything because you are only praying on the submitting on the stay,
Yes.
right? This will be kept for the final disposal. Anyway, so Sonu Bhatti, which this is where
Phase
Delhi High Court judgment. Page
3, paragraph 12, 13, and 15.
page 3, paragraph
12, 13, and 15.
13 and 15.
And at page 10, paragraph 19 to 22. At page 10, there are 19 to 22. My lord, next case is Rameswar and others. This is for my lord CRP 28, item number 14. When right accrues, it cannot be negated by subsequent development. My right accrued on 22/12/2065. That is for, if at phase 6, middle paragraph, in P. Venkatas Varlu versus Motor General Traders. Against the withdrawal of letter.
Name of the case.
Rameswar and others. Judgment believe. The question is when right accrues, it
Pep-
cannot be negated by
It's page
phase 6, middle paragraph, in Venkatas Varlu versus Motor General Traders. Relevant paragraph. Thereafter, I'm also claiming for status quo ante 22/12/2025. For that, another case is Satyavrata Vishwas. Para 19/20/21. Status quo.
You are seeking status quo ante from you are seeking stay of the implementation of the new voting.
Yes.
That is your prayer, right?
And my lord, I have submitted my list of the case and
Because the other side is also not there.
yes, they have received the dusty on
but they are not-
33 months. They are not
Moment,
30.
moment the interim order is given, they will come running.
Yes, my lord. They have violated, conducted election. Even violation is on evidence now. Violation proceedings. My lord, basically, the impugned order, my lord, at my CRP 37, phase 29 to 31, the reliance was only relying on two case law, they have stayed. Whether it is not applicable. The case led by the appellant in civil litigation. This is not, my lord, applicable. My lord, first Shipping Corporation of India Limited. If my lord see the order,
But see, the thing is that if it's not possible to dispose it of, I cannot carry this file because it's a pending matter.
my lord,
I cannot carry this file, because it will be required here. It's not a final order.
but at this stage,
So I'll have to dictate it here only.
my lord, at this stage, my simple prayer is to stay the order of the senior division. That is for 10/4/2026.
That is your immediate prayer.
Yes, interim prayer, page number 29 of my CRP.
Broadly, I've understood. I'll start the dictation.
My
Then,
lord.
in the meantime, in between, I'll take your
My
residence. You can have a seat. Eju, you can record. Use that. You're Mr. M. Ate. Heard Mr. M. Ate, learned counsel for the petitioners. Full stop. Para 2 of the order dated 21/5/26 will be same. Full stop. Next paragraph. By the order dated 21/5/2026, the petitioners herein who are two in number were directed to take steps by Dusty Mode upon the 28 respondents.
Yes.
28 respondents implemented in this civil revision. It is submitted that accordingly, Dusty service was resorted to and an additional affidavit, indicating compliance of the same was filed. The learned counsel has taken the court through that additional affidavit. Where is your compliance affidavit?
My lord, I have filed
Page?
it separately filed, I think. That it should not be take along the
There is a general additional affidavit. Otherwise,
general additional affidavit.
okay.
Compliance.
Uh, No, this is different. You're bringing on record some documents. Right, this. Where is the compliance? Keep the judgment separate. From 300. Oh, this is the one. Additional affidavit dated 5/8/2026. It is stated in paragraph 3 thereof that the notice, dusty service was effected on respond number 2, who also received the notice on behalf of the other 27 respondents. The notice acknowledgement is annexed and it is dated 30/5/2026.
Yes.
However, none has appeared so far on behalf of the said 28 respondents. Has the case report come? No. I think it was not called also. It was not called also. From the order sheet, I find that the case record has not yet been called. Therefore, call for the scanned case record of which will be necessary
My lord, both from senior division Pasigat and junior division.
of civil appeal number 2 of 2026
Yes.
and miscase or the title suit.
Miscase.
Miscase number 2 of 2026, civil appeal number 2 of 26, as well as from the court of the learned civil judge senior division Pasigat and the scanned case record of miscase number 2 of 26 from the court of the learned civil judge junior division Pasigat.
Pangin, my lord. Pangin.
Or not Pasigat.
Yes.
Pangin. PANGING.
Yes.
Full stop. Next. The learned counsel, Mr. Ate, submits that he seeks a stay of the impugn order dated 10/4/2026 and addresses the court in support of his contentions regarding the same. Full stop. It is stated and submitted that the original dispute was pertaining to election to the ADI Students Union, which process is determined by the bylaws of the parent body, that is Adi Bane Kebang within bracket ABK, as well as the bylaws and constitution of the Students Union. That, as per the rotational system, the post of the president for the session 2025 to 28 was recorded. Have a seat. I'll tell you. Yes, you sit down. I'll tell you. For the session 25 to 28 was recorded to be allotted to the Yomi district, but
Yomi, my lord.
SHI, Yomi district. However, erroneously, the same was allotted to Namsai district, leading to intervention by ABK through resolution number 7 dated 14/11/2025. Subsequently, the said resolution dated 14/11/2025 was challenged by the respondents, right?
Yes.
Respondents by way of a title suit being TS number 11 of 2025.
My lord, respondent number 1 challenged.
By respondent number 1 before the learned civil judge junior division. Tanging. Full stop. In the said title suit, an interim order was passed on 22/12/2025, directing deferring of the election process. The further contention of the petitioner is that despite the subsistence of the interim order dated 22/12/2025, the election process was carried forward and the candidates were declared elected unopposed on 24/1/2026 and 25/1/2026. It is full stop. It is contended by the petitioner that such a course of action was violative of the injunction order, and therefore proceedings under Order 39 Rule 2A CPC regarding violation of injunction order was preferred, and that the same proceedings are pending. It is further stated and contended that in the said proceeding preferred under Order 39 Rule A CPC before the learned trial court, the said learned trial court passed order dated 9/2/2026 in miss case number 2 of 2026, staying the operation of the list of candidates declared on 25/1/26 as mentioned above. Next paragraph. Aggrieved by the said stay of the aggrieved by the such stay of the operation of the qualified candidate list dated 25/1/2026, the present respondents is
Well, not only declaration of candidate, their election was also state declaration of result. 25/1.
the declaration of the election results. Just expand that. I'll correct it later. The present respondents who were it is stated that the present respondents were the newly elected members by the aforesaid election, and aggrieved by the stay order dated 9/2/2026 passed by the learned trial court. They preferred civil appeal for the court of the learned civil judge senior division, Pasighat, which was registered and numbered as civil appeal number 2 of 2026. In the said civil appeal, the learned appellate court passed the present impute order dated 10/4/2026, suspending the stay order dated 9/2/2026 passed by the learned trial court within bracket civil judge junior division. In the said facts and circumstances, the petitioner is now before this court with the present revision. Full stop. Next paragraph. The learned counsel primarily contends that as the election was held and the results declared despite the subsistence of the order of deferment of elections, vide order dated 22/12/2025 passed by the learned trial court in TS 11 of 2025. The subsequent election was null and void in law, and therefore in the miscellaneous proceeding being miss case 2 of 26, the learned trial court rightly state the operation of the same. However, as already stated in the appeal preferred against the said order of stay, the appellate court was pleased to reverse the same. leading to the grievance of the two petitioners in this revision petition. Full stop. I'll not make it very long. Thanks for the filing. I'll just refer to the judgments you mentioned
My lord.
about really anything done during the subsistence of
Okay, my lord.
those judgments only have.
Madam, no problem.
Where's let us see the two impugn orders first. Both the orders. Just give me the page number of
My lord, passed by senior,
all the three.
senior division, my lord.
No,
Page number 29.
starting from this 2212.
2212 is, my lord, at the page 239.
Then
9/2/2026 is 294, whereby the state election result was state
9/2/2026 is
294.
294.
My lord, 2811 also relevant at 235. First interim order in favor of them, which was subsequently modified.
235.
It's 2811 to 2025.
Then last one is 10/4.
Yes, 10/4. 10/4 is
Page.
phase 29 to 31.
The suit is disposed of. Yes.
My lord, after violation of the interim order,
Hmm.
they went and withdrew their original title suit. But before withdrawal, I have already filed the violation application, number 1 of 2026, which is still pending. Thereafter, I filed another miss case.
This is very complicated then.
Yes. Basic ground for stay of.
Because he has referred to this that there was no suit. So the interim
Yeah, that was
injunction
their-
order cannot be granted.
That was their observation. But
As on today, there is no suit.
misapplication, violation application are pending, my lord.
No, but the suit is withdrawn.
Yes. Withdrawn is only to escape the violation.
No, that's different. But
Yeah.
when the suit is withdrawn, all the interlocutory proceedings also end.
That is the general assumption, my lord. The case they have cited, relied on, is not applicable in our case. That's a different subject matter.
So on the face of it, there was no mistake in this order.
Yeah, on the face of it, it seems
how
like
can
that.
it be
It's a
stayed?
general,
And how can it be stayed?
my lord, that is why the power of the contempt court to declare contempt of transaction void and non.
Because is there any stay in this other revision which you have filed against withdrawal?
No, that is, no, I've not made no interim in 28, because it's just for the withdrawal, against the withdrawal.
I perused the impugn order dated 10/4/2026. The learned appellate court referred to the decision of Cotton Corporation of India versus United Industrial Bank and Shipping Corporation of India versus Machado Brothers, which was submitted by the appellants to contend that as the main suit has been disposed of, therefore injunction cannot be disposed, cannot be granted in the disposed of case. On this point, the learned counsel for the revision petitioner fairly submits that when the proceedings pertaining to violation of the interim order was pending, the respondents withdrew the suit.
Yes.
Withdrew the suit. Full stop. Against the said withdrawal, the petitioners have filed a civil revision before this court, which is registered and numbered as 28 of 2026.
My lord, at least when the violation proceeding is pending, I should be heard before permitting the
It's
withdrawal.
true, but upon perusing the case record of the civil revision 28 of 2026, I find that till date, no interim order has been passed in the said. Yeah, because because then in that case, the suit is not there. In that case, the suit is not there. Then can we quarrel with this order? There's no suit because this
My lord,
this
the-
position is quite clear that when
My
the
lord-
suit is not there, how can they pass?
My lord, order dated 9/2/2026 was not passed in title suit. It was passed in misapplication,
But-
violation application.
No, then all the connected applications will go. with the
My
withdrawal
lord,
of the
suit is different. Violation proceedings is a separate proceeding, like contempt. It's a separate proceeding. It is between the court and the contemptor and the violator. It's a separate proceeding, my lord.
So the whole subject matter of the suit is not there now. The suit was challenging because you are seeking stay of the election.
Yes, my lord.
The whole suit was pertaining to that.
Yes, my lord.
Was
My
whole
lord,
suit was
in the
pertaining to
title
that.
suit-
That is gone.
My lord, in the title suit, I have filed my counter affidavit. So my right accrues. That is why I have submitted the.
No, I think that this is
Because my lord, I have been made as a party, impleaded as a party. I have filed an application, I was impleaded, and there was a violation. In fact, initially they were, the interim order was in favor of them. When it was modified, first they withheld the election, thereafter they filed first civil appeal 1, then CRP 9,
the
which
first.
was
We should
withdrawn.
always first take the court to the impugn order. Read the impugn order. We started with case law, so many case laws, but the fact is that there's no suit. What interim order will be passed
My lord,
by the court?
I have, in the initial, I have submitted, my lord, they have withdrawn your title suit. My violation application was pending. Before withdrawal, I have filed. My lord, how can one, after violation, my lord, for instance, after filing a CRP and obtaining an interim order, which are vacated, then I, after violation, come back and withdraw. How can court allow that, my lord?
No, that is a subject of challenge.
My lord.
And there's no interim order that the suit will be taken as pending.
My lord, my violation is pending. Is it in the state of evidence?
But the whole matter has arisen out of the main suit.
But the order, impugned order, is passed in violation application, my lord. That is separate proceedings. And the contempt court has a power to undo the wrong. That is, my lord, I have submitted Sonu Bhatti case. The power of the contempt court to declare contemptuous transaction void or non-est in the eye of law. That, my lord, I have submitted.
Wait, just hold on. We have not gone systematically. You have jumped the stage and straight away, we should start with the impugn order. The impugn order, mentions a significant question of law. It mentions a significant law point.
My lord. I might have.
Just a minute. When was the suit withdrawn?
My lord, it's withdrawn on, it's here. My lord, 0402. Violation I filed on
04?
0402
2026.
26. My application, violation application was on 27 January 26. Before withdrawal, I filed a violation, my lord.
See, the point is that the subject matter of the stay of the election, the issue of the matter of subject stay of the election was the subject matter of the main suit.
My lord.
Right. Now, if the main suit is not there, how can that subject matter of the election be stayed? That is what the appellate court said.
My lord, it is correct, but
And
my
it is
lord,
not completely wrong. It's
My
not wrong, actually.
my lord, in fact, what they did was, they didn't make us as a
Yes,
party.
their conduct was doubtful.
Thereafter,
They withdrew that proceeding. That can proceed.
not only that, my lord,
Different thing.
against
It's like
this-
contempt.
my lord, not only that, or against the order of staying the election result, they prepared CRP. This coordinate bench of this court didn't pass any interim order, not inclined to pass any interim order. Then they withdrew up and then they go back to senior division, because senior division was on the hearing of other appeal was inclined.
The learned appellate court in the impugn order dated 10/4/2026 observed that as the main suit had stood disposed of on the day the interim prayer was made by the petitioner as applicants, and therefore there was no merit in passing the interim order in the absence of the subsistence of the main suit on that day. Full stop. So it may not be possible to pass any order staying this, because prima facie it is not wrong, actually. On the face of it, it's
My
not
lord, but
wrong.
my lord,
Because,
interim order
I'll be
violation
passing a
conduct
wrong order,
election.
because these laws, this Cotton Corporation and Shipping Corporation lays down it very clearly.
No, my lord, in this case, there is no violation application. It's just in shipping corporation, my lord, of the shipping corporation.
You give me the decision. then.
It was, my
Give
lord,
me both the decisions, Cotton Corporation and this,
Yes.
take out both the decisions.
what the decision, my lord. My lord, shipping,
If there is some interim order in this, putting on hold the withdrawal of the suit and holding it to be pending, then it is possible to pass any order, not otherwise.
my lord, shipping corporation, my lord, here there was no violation.
So withdrawn
application.
suit, the court has to pass an interim order, holding it to be, putting on hold the withdrawal, that means holding the suit to be pending. And then only you can pass.
My lord, withdrawal was on February.
Long time.
Already withdrawn. Before withdrawal, I filed an application for violation. It is admitted and it is on the evidence scale now.
Full stop. It is, next paragraph, it is submitted by the learned counsel that at the behest of, though the proceeding pertaining to violation of injunction order was pending, the respondents withdrew the suit, the main suit being TS so and so we have written on 4/2/2026, against which the petitioner has filed a criminal civil revision, the connected civil revision, as already mentioned earlier. Yes, let us see those decisions. You have.
My lord,
Take it up, otherwise.
my lord, shipping corporation, my lord.
You have?
Yes, my lord, I have submitted.
You are at liberty to file an interlocutory application in this. Though it's not usual, it's a disposed of suit. What can you really pass? But still, in this backdrop, in these circumstances, this interlocutory application, if you file, this can be taken up for hearing. That this was done in a way to circumvent that proceeding.
My lord,
Which of course stands on its own footing. That is true. That is true. And the plaintiff has a right to withdraw his suit. That is also there. But
my lord, the learned court below would not have allowed the withdrawal when there is a violation. At least should have heard.
yeah, that I agree with you. So in that,
So without, in our absence, they withdrew. We didn't knew. Thereafter, we came to know, then
the
we,
learned counsel for the revision petitioner submits that the learned trial court ought not to have allowed the withdrawal of the petition, especially when the proceeding pertaining to violation of injunction order was pending, and without hearing the petitioners as defendants in the suit. I have not seen that petition. Shipping Corporation. Okay. Let us locate the relevant paragraph
madam.
of these.
I submitted my
No, your copy, please take your copy.
My lord, in shipping corporation,
These two matters have got stuck in some complexity.
my
actually.
lord, in shipping corporation,
Because of this, actually.
my lord, shipping corporation, what happened was,
Mm.
first, there was a notice for termination of the agreement.
Mm.
That was challenged interim part. Thereafter, after 6 years, again, another on new ground termination notice was sent.
Mm.
Against that, the petitioner contended that there was
Mm.
interim order
Mm.
in earlier notice of termination. So in second, there was a new ground. So there was no violation application. So in our case, it is different. The fact is there is a violation application already pending before withdrawal. And Cotton Corporation is, my lord,
Wait.
shipping corporation.
So you have highlighted only yourself. Come to page 8, you have yourself highlighted. This is clearly mentioned here.
My lord, in that case, my lord, fact is there was no violation application, my lord. And that suit was after 6 years.
No interlocutory application will survive after the original proceeding comes.
Yes, my lord. But
Sabita
there was,
Rehan, yes.
there was
I
no
remember
violation
now.
application pending, my lord. This is bit different. The case is, fact is different, my lord. In our case, there is a violation application pending, my lord. And in, my lord, Cotton Corporation, my lord, at page 8, the question is different. The question.
No, but the interim order which you are seeking is staying the, staying the election.
Yes, my lord.
Right. That was a subject matter of the main suit.
No, subject matter was
Of the main suit.
main suit. Subject matter was.
And that is the suit is not there.
No, main suit was, my lord, the allocation of president post, not election. Main suit was for allocation of the president either to the COME or to the.
But the stay of the election was passed in the main suit.
No, IA in IA 20.
IA in the main suit.
Yes.
IA was filed in the main suit.
Yes.
Right. IA in the title suit.
Yes.
The stay of the election was passed in the IA,
Yes.
which was filed in the main suit.
Yes.
Now, when the IA title suit itself is gone, only the violation proceedings subsist. But all
My lord,
others are
that
gone.
time our right accrued because we became the party and we filed our counter affidavit. So our right accrued. That's why, my lord, I have submitted one. When right accrues, status quo ante must be bring back by the,
Then get the records and go for final hearing of the entire.
my lord.
That
Till
would
that time, my lord, at least,
No, no,
my lord, because my lord, there is a student
no,
election.
no, I don't.
Two my lord, two organizations are functioning now. And
I-
there is, it is like, my lord,
No,
keeping,
no, that will be passing a wrong order because the order, this is very clear that there's no suit. That's why they have not passed.
my lord.
There's no suit, there's no suit, therefore the interim order cannot be passed.
But my lord, there is a violation, my lord. Violation application, I have already filed before withdrawal, my lord. So just to avoid the violation proceedings, they withdrew clandestinely, which we, in our absence allowed. That's why we're also challenging that, my lord. In CRP 28. My lord, if,
I cannot express any opinion on
My lord,
this, because this is subject of adjudication.
my lord, if such conduct is allowed,
No, that's true. The conduct is very bad, but you can file an IA in the other one.
my lord, in, if my
You
lord,
have to revive the suit.
my lord, if my lord see the impugned order, it is almost a final order, my lord. He observed it to be not maintainable, my lord, without considering our submission. Because, my lord, the stay was filed in violation application. Therefore, my lord, the contempt court has
The,
power
upon
to bring
upon
back.
perusing the impugned order dated to 10/4/2026, I find that the main reason why this the order was passed was that that the suit came to be disposed of in the meantime, and therefore the prayer for interim order could not be considered in that situation. The learned appellate court referred to the two decisions of Cotton Corporations, Supra, and Shipping Corporation, as already mentioned above. Uh, As the merit of the order is a subject of adjudication in the present revision, therefore, no opinion, no detailed opinion regarding the same can be passed. However, this court is not inclined to pass an order of stay as on today. Stuff. List the matter. Get the records very quickly. I think this matter needs to be heard and finally disposed of. And I don't know about this. If it is possible, then you can regarding your dismissal of the suit.
My lord.
It has to be. I mean, because this aspect that it was in a way behind your back.
My lord.
So the dismissal itself, needs to be looked into. List the matter after 2 weeks.
My lord, a fixed date may be given, my lord.
Okay, fixed date, please.
Uh,
After list the matter on so and so date. In the orders column. Take a date. As soon as it comes, we can fix it. Okay.
Maharaj, then observation may be given that endeavor may be to dispose them petition. Even if they don't, my lord, FER, because I have already 3 months ago.
Their appearance is no longer material because you have served.
My lord.
The case won't remain stuck due to their non-appearance.
My lord.
The records have to come. Best would be to hear it and dispose it off. Learned Counsel praised for fixing the matter on 2nd September. List on 2/9. This will be a related petition of the other matter.
My lord, but it is such, my lord, 38 for against the withdrawal.
True, it is a, this should have been brought, or the court should have given you an opportunity.
I might
to
have
yourself.
grasped the attention, but I submitted that withdrawal.
No.
Might not have grasped the attention of the court.
No, I got it. Mr. Amate, Learned Counsel. Here also dusty service was taken? No.
No, my lord, this is, my lord, no dusty was taken, but
Would you like to take?
my lord, I was,
Because this has more urgency actually. Because the whole problem arose because the final stay of the appellate court was done in, circumstances which are not very,
my lord, in fact, what happened when CRP against this order, suspension.
not very positive.
My lord, when
you know.
CRP was heard,
Mm.
they filed another civil appeal there, one. During the course of hearing of civil appeal one, when senior division came to know that issue is
The
pending before
conduct has
High Court.
not been very good. Otherwise, I mean,
In fact, my lord, if my lord,
probably the appellate court would have taken a different view, perhaps, if the suit was pending, perhaps. We don't know. Anyway, that's past now.
or in fact, these two cases, reliance was not applicable in our case, my
Mm. Service not yet received. So here, service report is still awaited.
my lord.
I think you resort to dusty service. No, because this has even more urgency, as I said. The instant civil revision has been filed. You para 2 of 27(4) you can take. Full stop. And Mr. Ate, Learned Counsel submits that while the application filed in the title suit alleging disobedience of the order of stay passed by the court was pending, the respondents withdrew this suit, and the revision petitioners herein did not even have the opportunity to have their say in the matter. Full stop. Agreed by the said withdrawal, the instant civil revision has been filed, as already mentioned above. Full stop. As per office note dated 6/8/2026, service report is still awaited upon. Here the respondents are?
Only one, my lord.
No, two respondents?
One is the original plaintiff, Jirbojamo,
Just a minute.
the original plaintiff in title suit, which was withdrawn.
Uh-huh.
And other is ABK, Adiban.
The organization. So who will receive? Well, okay, the president will receive.
Yes, my lord.
This is the petitioner is allowed to take dusty service by dusty mode upon the two respondents impleaded in this civil revision, followed by filing of a compliance affidavit.
My
Kindly
lord, I
do
have
it.
a small player, my lord.
Yes.
My lord, we have filed another new title suit challenging the election result. So this pending this CRP may not be an impediment for passing any appropriate order in the junior division. That may be observed, my lord. Kindly, my lord.
It is submitted by the Learned Counsel that another title suit. Do you have the number?
Title suit 6.
Title suit 6 of 2026 has been filed by the petitioners
In junior division.
before the Court of the Learned Civil Junior Division.
Challenging the election result.
Challenging the
Declaration of result election.
dated 25.
And 24. 24 25 January.
Challenging the declaration of the result to the election of the student body. Dated 24/1/2026 and 25/1/2026.
Yes, madam.
Full stop. The pendency of these revisions,
Both revision, my lord.
both the revisions would not be a bar to the Learned Trial Court passing any appropriate orders.
My lord.
in that
Thank you,
case.
my lord. Obliged, my lord.
So this also on the same date,
Yes, my lord. Same day.
second.
Ma'am.
You give the decision, citations,
Ma'am.
case law. I'll keep it in the file. Should I keep it in the file? It will be needed for the final year.
My lord.
Or if you want to take it, you can take it and submit it.
My lord. Then I will.
You can resubmit on that day.
Matter number 16 and 17.
Yeah, so you can go. You can come in. Get lecture.
Yeah, Your Honor.
Item,
Item 16, Your Lordship. 16, 17, yeah,
Okay.
connected. We have filed one IA,
okay.
IA number
In criminal
78,
petition,
criminal
you
petition
want
on
to
the
amend it?
case for amendment, Your Lordship, to the
No problem.
Yes, sir. Lordship, I have filed IA number 63. In item number 17. It ought to have been in item number same, I think, because it is filed in.
No, it's like that only. IA 78 with criminal petition 188. With IA 63 and IA 78 are both in criminal petition 188.
And my IA I have filed long back.
Hmm,
My IA is for vacation of interim order.
I see.
The interim order is operating in the matter since 2024,
Okay.
2 years back.
Mhm.
It is against the proceeding before the
Learned court below. I'll come to it. I'll come to it. Which one should I take up first?
My prayer is, if it is to be taken up, my IA should be taken up first.
First?
I had filed long back, and it was, in the bar, it was arrived, I would say, the understanding was arrived that it shall be taken up on 12.
Hmm.
By order,
I'll just come to that. What amendment you are?
Your Honor,
you want to
amendments,
make? I'll just.
yes, yes.
What amendment do you want to make?
Earlier, this instant petition was filed only for quashing of the FIR.
Oh, so that one.
Now,
You are
since the-
upgrading your prayer.
Yes, now since the charges has been filed,
That's
so
fine.
I'm,
That will be necessary. in any
yes, it
case,
will be necessary.
That will be necessary also, isn't it?
the charge sheet,
Hmm.
by way of additional affidavit that they have brought before this honorable court in the year 2024.
Hmm.
Now they have waited 2 years
Hmm.
to, I'm just.
No, at the time, no, at the time of filing of the criminal petition, it was, charge sheet was there.
Not there, but
Oh.
subsequently they have brought the
Oh,
additional
they-
affidavit in the year 2000, because the
No,
matter is
very late,
2023.
very late.
23, it is pending. After coming to know that charge sheet has been filed, they have brought by way of additional affidavit. They have not whispered anything
About?
the amendment, because they have,
Okay.
they have brought before this honorable court that by way of additional affidavit, the charge sheet that has been.
Got it, got it. We'll go it and then go into it. What kind of interim prayer was, what kind of interim order was made? Stay, because at that time it was under investigation. Let us see the order dated 4/9/24. Okay.
Yes, 4920.
49 before, yeah, in that my lordship, keep that my, I mean,
This I am on your eye only. 63.
12, 11, 12. No reason order. I have categorically mentioned the circumstances, how the.
I'll come to that. Order dated 4/9/2024. Okay.
Others put access to others for safety. It's me.
Miss Hage, should it come up before the same judge?
And Lordship, the interim was passed on the from I think
6/9/23.
yes, Lordship.
But the learned judge, it has to be by video online because he is not here. But he is available in the court. In the court, he is available,
Yes, Lordship.
but not in the bench.
Yes, Lordship.
Okay, I can go through the order.
Lordship, the bail only Lordship, I think that's the same bench Lordship. Otherwise, regarding the stay Lordship, the interim Lordship,
Hmm.
it may be vacate any court, other court. It may be heard from by any other court Lordship.
Also,
Yes, Lordship.
no bar.
No, not necessarily Lordship, the same bench Lordship. Only the interim protection is there Lordship, not a final order.
Where is the page?
Page number 11, 12.
Okay, wait, so this one. Now I was seeing another one. So the criminal petitions, so and so. The list the matter till the returnable date. Okay. Further proceeding of sessions case number.
And I have made category.
So when this order was passed in 24, That means charge sheet was already there.
Charge sheet, no, subsequently charge sheet was filed.
No, no, and because the proceedings are
Yes,
before the sessions court.
Charge sheet was filed.
Huh? Because sessions case has been registered.
And,
It had already come before the court, that means, was stayed.
the TCR is before the court. So only this will delay the proceeding. And I have categorically mentioned in paragraph 2,
Let me
how
see.
there was circumstances which whatever passed.
Itanagar Women PS 85. huh? Ita Women PS number 85 of 2023. What is the stage? When it was stayed. Can you are you in a position to tell me what was the stage when it was stayed? Consideration of charge.
Stay was granted after 1 year of this proceeding pending before December. Because it was in the recess time when
I'll come now. I come to your contention which you wanted to show. Scan record is also available.
Lots of everything is there.
Show me your contentions page.
the page 12 is there.
No, 12 I found. This is okay.
May I?
But your petition,
Yes.
your application, the contentions.
Lordship, initially the case was FIR was registered under section 376, 420 and 506.
Right.
Then the petitioner, because the case was registered before the moment he is done with. Petitioner applied for the AB. AB was granted. We objected. While granting the AB, the Honorable Court directed the Superintendent of Police to monitor and supervise the investigation. Because he himself, the petitioner himself is a police inspector. Under the supervision of the Superintendent of Police Itanagar, detailed investigation was carried out, and subsequently the charge sheet was submitted. And the charge sheet, when it was submitted after detailed investigation, the section under which it was submitted was
376, 493, all these.
376, 493, 420, 468, 471, 204, 506. So it was independent witnesses were examined. Not that only victim's statement was taken. After detailed investigation, the charge was submitted. Lordship would not appreciate me sitting on to decide under 482.
Yeah, no, that has limited scope, of course.
So,
We cannot be a second trial authority. That's well settled, all these things.
so there are sufficient material to go for trial. If they are agreed, they can contest before the learned trial court during the course of CC. They have the option, they have the remedy. But my humble and respectful submission is not by way of criminal petition under 482. The Lordship may come to the charge sheet which they have brought.
One thought that has come to my mind is that his amendment can be allowed. Let him make the amendment, and records are also there. It's best. Already there is a lot of delay. Best is matter should be heard and disposed of.
Yes.
What do you say?
Lordship, then my IA, I'm praying for my IA.
No, because I if it is heard, suppose if the matter is heard on a mutually convenient date, then I will merge into that.
Yes. Matter is already
It's of-
fixed on 12th of August.
So it's already
Fixed.
on
Mhm.
12th of
Yes, yes.
by order dated 20 of July 2020.
Which matter?
This matter. This main case.
IRA as well as
Main case. Yes, yes.
Okay.
In the IRA it was passed, order was passed
Okay.
for disposal of.
Fixed on?
12th of.
Then it's okay.
Yes, yes.
You make the amendment.
Yes,
however,
yes, yes.
In the meantime, you make the amendment. Because no point wasting more time.
Yes, yes.
Dispose it off.
My only humble prayer, Lordship, since the PCR is already near.
But I will make an observation that there is further delay in disposal of the criminal petition. Then you can agitate your prayer in the IA or state so that the proceedings can restart. You can make that prayer. The court will consider. Please work out a date.
Yes.
It's already fixed on 12th of.
Already fixed on 12th. Sorry, we've already mentioned. Just take this. Stop. IA 78 of 2026. Your good name, please.
M. Kambo.
KM Khamu, learned counsel for the applicant petitioner. Full stop. Along with learned L. Hagen, learned additional PP for the state. And sir, your good name? Learned counsel for the respondent number 2. Full stop. Private respondent. Full stop. By way of this interlocutory obligation, the applicant petitioner seeks to make some amendments in para 4 of the criminal petition and insert additional paragraphs being 4A and 4B, which are narrated in para 5.1 of the interlocutory application. The next paragraph. The applicant also seeks to add to the prayer portion by inserting prayer number 2A and 2B. It is submitted by the learned counsel that when the petition was filed, they had prayed for quashing of the FIR, but in the intervening period, charge sheet has also been filed, and the case is now pending as sessions case number 1 of 2024. Though it is under an order of stay. Further proceedings are under an order of stay. Upon perusing the proposed amendments and considering the matter, the petitioner is hereby allowed to make the said amendments as indicated in para 5.1 and 5.2 of the interlocutory application. The IA being IA number 78 of 26 is allowed and disposed of. What will you do? File a fresh petition?
Yes, I will file twice.
You file?
Amended one.
12 is
next week.
Yes.
Still again,
No,
No, I
file-
will file before that.
File it quickly.
Yes,
they
leave.
can, that they,
No. I- before that. In
The,
a day.
the petitioner, applicant petitioner shall file a fresh petition incorporating the amendments and expeditiously furnish a copy of the same to the other side,
Yes.
to the prosecution as well as to the learned counsel for the private respondent.
I need.
63 has not come up today. Has it come up today?
Only in June, no? Like it.
In the main proceeding, that is criminal petition number 188 of 2023, coordinate bench of this court, by the order dated 4/9/2024, was pleased to stay the further proceedings of sessions case number 1 of 2024. Pending before the, where is it pending? And it's session judge UPA, full stop. The initial order was still the returnable debt, but it has been extended from time to time, full stop. The applicant was the respondent number 2 in the criminal petition and informant of the case submits that he is prejudiced by the stalling of the proceedings of sessions case number 1 of 2024, and therefore has filed the instant interlocutory application seeking vacation of the aforesaid order of stay dated 4/9/2024. The scan TCR has also been received, full stop. The learned counsels on both sides have mutually agreed that endeavor would be made to hear and dispose of the main matter, which is stated to be already fixed on 12/8/2024, full stop. Accordingly, this interlocutory application may also be tagged with the said matter and posted on 12/8/2026, full stop. It is observed that if for any reason there's some delay in disposing of the main criminal petition, the applicant would be at liberty to agitate his prayer for stay of for vacation of the stay made in this interlocutory. Yeah, that should be, I think it should be possible to dispose it, dispose it off.
Yes,
You know, here, well, even if you cannot complete in one day, start the hearing and then next day, because the learned judge will be there for 2 weeks. Huh?
Item number 18.
Another one.
My lord, I am filed IA for amendment of the petition,
This is also
criminal
amendment.
petition. Because during the pendency of the case,
Just a minute.
charge sheet has been filed.
Same, no?
Yes.
So investigation, now a charge sheet.
Yes.
I may be disposed of last week.
Disposal.
And
All have come, record have come, charge sheet has come.
no,
That will be necessary for
yes,
disposal.
so we had called for
Record not. Oh.
reminder should be
What about service? Service is there?
service lost if
Service has been completed, but in the
Come back. In found address. Can we have? While I dispose it of, you can have it. Pass an order in the main application also. The similar order. IA 79 of 26. Your good name, please.
PK core.
Okay, Ghosh, learned counsel for the applicant, petitioner, and El Haji learned additional people. The instant application, interlocutory application has been filed by the petitioner seeking amendment of cause title of criminal petition number 1 of 2026. It is stated in para 2 that the petition was initially filed for quashing of the FIR number 119 of 2025 of Naharlagun PS. But during the pendency of the main proceeding, charge sheet was submitted on 16/1/2026. In the circumstances, the prayer for amendment is sought to be made instead. The proposed amendments are indicated in all these amendments you want to make. Para 5. Para 5 of the petition. By incorporating all the details, all the additional details pursuant to submission of the charge sheet. The prayer is allowed. The applicant petitioner may make the necessary amendments and file indicated in para 5 of the interlocutory application and file an amendment criminal petition. With
Memos of the parties also.
Hmm?
Memo of the parties
including
also.
memo of the parties.
Yes.
Copy of the amended criminal petition shall be furnished to the prosecution.
I have
And-
already received those.
You have received,
Yes.
has already been furnished to the. No, this is not yet allowed actually.
Oh.
Yes.
So will be furnished.
Yeah.
No,
I-
you will receive it, but the language will be furnished. That's okay. That's between you. But the thing is that in the context of the amendment petition, he has to send a fresh notice. It seems.
Yes.
it has come-
Fresh notice may be.
it has
I will
come
take
back.
a step.
The IA is allowed and disposed of.
Apply.
Then reminder maybe sent to call for the screen copy of TCR also, because TCR last occasion we have called for the TCR, but it has not come yet also.
Yes. This I will pass on the main order, main proceeding. By order dated main case, by order dated 17/6/2026. Scan TCR was called for from the Court of the Learned CJM UPA, but the same has not yet been received. Issue fresh requisition for the scan TCR of. Kindly give the case number of Naharlagun PS case number 119 of 2025. You have the GR number, right?
Yes.
Please give me the GR number. GR number.
Year number 766, 2025.
766 of 2025. CJM UPA.
Yes.
The scan record should comprise scan copies of the case diary, charge sheet, and other relevant documents. Full stop. Though the petitioner, there are several respondents.
Yes. All the complainants.
They are all complainants.
Yes.
Though the petitioner had taken steps upon the respond number 2 to 6, within bracket being the complainants. But unserved notice has been received from respondent number 4, indicating insufficient address. Service report with regard to the other 5 respondents is awaited. So you take fresh steps, because since this is amended, the petitioner shall take fresh steps by speed post upon the private respondents, being respond number 2 to 6. Okay. List in the orders column after 3 weeks.
3 weeks.
Any interim order?
No.
No.
No. Alright.
Item number 19.
These two matters, Mr. Mehdi.
But
Just, I'm so sorry, I wanted to, you were waiting.
Morning, I mentioned so my item 20 is my urgent, my lord, at 20, my lord. 19, my lord, is proceeding sanction already given, my lord, regarding proceeding sanction, my lord. So, my lord, this matter will be fix another date, my lord. This already denied then proceeding sanction, my lord,
Okay.
by the government of India. my lord.
Okay. And against prosecution sanction,
Sanction.
that denial, you filed this petition.
No, my lord, it's actually, we are the army.
That,
officer, my
that will be a writ petition.
My lord,
No, challenging non-grieving of prosecution sanction has to be by writ petition.
no, I'm not, no, this, I filed this petition against the cognizance taken, my lord, without taking the prosecution sanction.
Oh, I see.
So, that was stated by this honorable court, my lord.
Oh.
So subsequently, the national government wrote letter to the ministry, my lord, for proceeding sanction. That was denied, my lord. So this, in PI, there is also PIL pending, my lord. In that case, my lord, DIG of the Arunachal Pradesh, my lord, letter was sent, my lord. This was denied by the government of India, my lord.
So we'll fix another day.
Yes, my lord. Yes, my lord. So, my friend, my lord, last occasion, is directed to take instruction also, my lord, to him also, my lord. My lord is.
Mr. Mary Leonard CG is appearing for the petitioners.
My lord,
You are appearing for the
I'm appearing for the matter SIT.
SIT
Yes. Respondent number 1.
in the capacity as special PP.
Specifically, madam.
Full stop.
I'm also, my lord, not as a central government council, as a parliament.
Yes. No. You are appearing in private press.
Yes, my
Okay,
lord.
so this is wrongly written. Learned counsel in this. The matter is adjourned today with a paucity of time. First, interim order passed. You give the date, by so and so date.
17th September, my lord.
Always better to give a date. Then we check. It compels us to check the order, but so that we don't miss sometimes.
17th of September.
Shall continue till the next date of list. Full stop. List on.
17th September, my lord.
The Learned Council prays for listing the matter on 17 September, list on 17.
Item number 20 is.
Item number 20.
I have urgency, my lord. So in this case, my lord, I've submitted written argument also, my lord, and the judgment also, my lord. Here, my learned friend is appearing, my lord. I am not taking so much time because my written argument is there, my lord.
Just a minute.
Written as,
In this case, you are appearing as CGC.
yes, my lord. Here, my lord, a very small issue is there, my lord. My lord, it is to decide, my lord. So, my lord, we are expecting from this honorable court, my lord, both sides, my lord. So here, my lord, this what happened, my lord, there is an arbitral award, my lord. So it was, my lord, this, my lord, expertise, my lord. My lord, subsequently, when award was passed, my lord, we filed for execution of the award, my lord.
Okay.
So the execution award, my lord, this initially, my lord, in award, when award itself, my lord, we have issue notice, my lord. It was not appeared, my lord. Arbitral issue notice not appeared, my lord. Subsequently, without receiving any from the respondent, my lord, the award was passed. This is the fact, my lord. So the award was passed. After the award was passed, we filed for execution under section 36 of the Arbitration Act.
Arbitral.
But in that case, my lord, sufficiently service was completed, my lord, even paper publication also there, my lord. So that it was initially in Sonitpur district, my lord.
Okay.
So there is an order for why he shouldn't go for civil prison. So it is there, my lord. But subsequently, the learned district just pass an order. The person and the property.
The executing court.
Yes, yes, executing court. It is belong to, my lord, the Arunachal Pradesh. It was transferred to West Cameng Bomdila, my lord. Bomdila, when it was in West Cameng Bomdila, my lord, the notice was issued, my lord, and in same address, when initially we issued, my lord, in same address we issued notice, my lord, the court issued, and they appeared before this honorable Bomdila district execution court, and they filed a petition under section 47 of CPC. In the said execution case under section 36 of the arbitration consideration. So that was my lord dismissed. This
Okay.
47 application was dismissed, which was filed in our 36 application, arbitration application dismissed.
Okay.
Subsequently, my lord, what happened, my lord, after third, my lord, they file and this
Arbitration. Okay.
after that, they filed a petition under section 34 of Arbitration Act, along with a miss case.
Okay.
Miss case.
Before Vice coming.
Yes, my lord. Miss case is, my lord, this section 34(3) of the Arbitration Act, along with section 14 of the Limitation Act.
Okay.
I am here before this on this when they filed this case, we filed objection. It is also in record in my petition itself, and our issue is section 14.
They contended that it's barred by limitation.
It is barred by because it is the order was passed in 2019 itself. They came. They received in 2023 October. Thereafter, they filed that section 47 application. It was dismissed. Thereafter, they filed with a miss case section 34 application. The miss case was filed section 34 3 of the Arbitration Act, along with the section 14 of the Limitation Act, but exclusion of that part which was dismissed 47 application. That is the case. So
wrong forum.
That according to them, they are the wrong forum. So they are entitled for exclusion of this. The learned district just allowed their application of this case. This was the wrong forum. So
this can be excluded. That is the issue, man.
That is the issue. We are agreed by that order. By the order, because the section 14 says of the limited same issues. I'm reading the section 14 of the Limited Act.
You are agreed by the order of the court holding that it is within limitation and for entertaining that petition. Under
We are exclusion part. So for exclusion part, section 14 is there, which was excluded by
Right. Got it.
court below. This exclusion cannot be under section because it is this section 14 not attracts in that particular case. Because it was they filed in my 36 application, subsequently 47 application, and now this section 34 which was filed, this is fresh issue. So that is different, and this case is different.
Can I have a look at this order?
Yes, my lord.
26, 11, 25.
This is
Page 211, man.
start from 212, my lord.
$200.
212 from the start.
Operative part.
Operative part, my lord.
215 down below the last line.
My lord, 223, lordship first may go to my lord.
Yes.
Now, paragraph 27. It is also seen the applicant received the copy of the arbitral award from this court only the 10/11/2023. That is noted after issuing notice from the West Coming. Selecting immediately prepared a petition under petition 594/2020 under section 47 on 16/12/2023. Challenging the both execution suit as well the award. But the award was not challenged. It was wrong, my lord. I will tell my lord. Therefore, I find no reason to hold that the previous application which ultimately come to be rejected for defect of jurisdiction was not filed with due diligence and good faith. In view of the foregoing discussion and keeping due the para 12 of the Consolidated Engineering Enterprises Supra, where this Honorable Supreme Court has elaborately discussed the legislative intent of Section 14 Limitation Act, I find this application for exclusion for period taken in a wrong form for preparing an application section 34 Arbitration Conciliation Act fit to be granted. Accordingly, within the period from 16/12/2023, on which the petition so-and-so was filed on 16/10/2012, on which same was dismissed for defect of jurisdiction, stands excluded in filing application under section 34 of Arbitration and Conciliation Act. As the applicant who received the copy of the arbitral award on 10/11/2023 has filed an application under section 34 so on 20/11/2024 for setting aside the arbitral award, as per my calculation appears to have been filed application under section 34 arbitration 69 days after excluding the period taken in wrong proceeding as held above. Therefore, I find the application filed under section 34 of Conciliation Act by the applicant not barred by limitation prescribed on so and so. Here, my lord, this before that, my lord, this.
So the basic issue is that whether this court has correctly interpreted the application of 14.
My lord, yes, my lord. Whether my lord, the
According to you, it is wrongly interpreted.
Whether application petition filed under section 47 in my execution case, and my lord, whether they first filed the section 34. That is the as per section 14.
They cannot be same.
That is the same one. So in this regard, I place a judgment of the apex court, my lord.
It's 2 minutes, right? Yeah, please.
And whether it is in good faith.
Oh.
Good faith.
Wrong forum, 2 things are necessary. From the statute only. I mean, the interpretation is, of course, there in so many judgments. But bona fide and good faith.
Bona fide.
Wrong forum.
Wrong forum.
I genuinely thought that the matter lies here, though it lies at your place.
Yes.
That is the view of the Supreme Court also.
So many decisions, but statute, that is what is stated in the statute.
Absolutely.
Yes, I'm not the
Many interpretations.
I'm not on that, my lord.
Yes.
If that is so, my lord.
So according to you, it was just a petition filed under section 47 CPC.
Section 47 CPC was filed in my execution case. And now they are filing an application under section 34 of the along with the miss case for exclusion. My lord, when the execution court, my lord, rejected the application under section 47. This lordship, this order is in my petition 112. 112, my lord.
Yeah.
My lord, initially
Yes.
filed 47 application, my lord, it's 43 minutes. Case 43 minutes. This was filed for, my lord, then application for dismissal of money execution case number 10 of 2023. Case 43 minutes. Because as I've already submitted my written argument, my lord, so I'll go to I'll point out something.
Don't worry. It's okay.
And in page 48, my lord, page 48, your lordship may produce page 48 from paragraph 11 of the state application. Whether they are in bona fide or not, my lord, this on this will or after my lord.
Okay.
With prejudice to its right in challenging the expertise award passed by the sole arbiter in an appropriate proceeding and before appropriate forum in due course, the instant application in being referred by the applicant without prejudice to its right in challenging the expertise award passed by the sole arbiter in appropriate proceeding before an appropriate forum in due course. So they are the award, it is required to challenge the arbitration award. So it is not that they are not awarded, but they file application for dismissal of the money,
Money execution.
execution. Yeah. Therefore, in page 50, my lords. Page, paragraph 23. In said circumstances, they awarded it on March 19, 2019, being executed as a decree in the instant arbitration proceeding, be declared to be null and void and inexecutable. Therefore, my that prayer portion, my lords, page 51, my lord. The aforesaid premises, the applicant most humbly prays that the Honorable Court may graciously to dismiss and set aside the present execution proceeding, being execution arbitration, arbitration execution case number so and so, along with the all order passed for passed such further orders or so and so may be required to person. So they are basically, my lord, this application was filed for, my lord, the dismissal of the execution. Here, my lord, what my lord, lordship may turn thereafter, my lord, the order passed by the in said case.
I'll come, just a minute. Yeah, I'll come to page.
My lord, it starts from page 112, my lord. And one thing is that with this for recourse of the award, my lord, challenging only the 34 is 60, 34. Okay.
Sorry, page 112, no?
112.
Oh my God.
112 is a very important. My lord. This everything was given in the when the order was passed, my lord. Observed, my lord. All
Order dated 1610.
yes, my lord. This what they want to exclude, my lord. This time, my lord. No, this one.
Oh.
My lord, here, my lord, this today present execution proceeding fixed for order in petition number so and so filed by the judgment debtor under section 47 not CPC, praying for dismissal of present execution and declaring the award passed by the sole arbiter is nullity. My lord, in their application, it is not there, but the orally they submit. My lord, so far, my lord, the only the recourse to a court against an arbiter award section 34, my lord. Section 47, that cannot be section. Decree may be, my lord, for 47 is for different. So it is not.
Questions of execution.
Yes, my lord. The determination of breaking in the and my lord, what? Well, in all this submission made by in section 47, my lord, regarding the ingredient, my lord, how they when a petition filed under section 34, my lord, all everything is, my lord, in the court also observed that.
Yes.
My lord, my lordship may prepare on section of my lord, paragraph 10, page 116, my lord. I have carefully perused section 34(3) of arbitration concern, which provides the service of arbitrator to be to the judgment debtor and a limitation of 3 months for filing an application of section 34 application as provided. It observed from the record that this case of arbitration is passed on 19/3/2019 as expert as petitioner judgment debtor has not appeared in the said proceeding. It is also observed that the execution of the said award, the execution proceeding was initiated and and on 1/2/2003, notice of the judgment debtor was published in newspaper. Thereafter, again, 30/10/2000, the notice was issued to the judgment debtor by this court, and judge appeared before the court on 16/12/2023 by filing a petition 594/2023 under section 47 of CPC. Petitioner judgment debtor has not opted to file any application under section 34 of the arbitration action, even after having knowledge about the award. Within such a period of limitation as provided, it is observed that as the application under section is not application under section 34 of the Arbitration Act, this court has got limited jurisdiction as provide under the law. So they are ever there in whole submission was made under when there's if challenge the case under section 34. And in page 115, my lord, this paragraph 8, I have heard the learned counsel for the petitioner regarding non-service of the signed copy of the arbitral award of judgment.
Para, you reading para?
Paragraph 8, my lord, page 115, my lord.
I'm here only. Para 8, I have heard.
I have heard the learned counsel for the petitioner regarding non-service of the signed copy of the arbitral award of the judgment debtor provided in section 34(3) of the Arbitration Act. To substantiate the pleading, the learned counsel has relied upon judgment so and so. I have carefully perused the judgment realized by the learned counsel for the judgment debtor and found all the judgment are connected with the application under section 34 of the arbitration. Present application is not filed under section 34 of the Arbitration Act. So the court is not exercised jurisdiction under 34. Thereafter, my lord, paragraph 9. It is further perused that the record of the case that the petitioner by WBC number 14110/2015 approached the Honorable High Court. By order the Iman has ordered that there is an arbitration clause in agreement between the parties, same be available by web arbitration, and the court has not exercised the jurisdiction under Article 226 of the Constitution. To transfer the petitioner had knowledge that the dispute among themselves be resolved by web arbitration proceeding as agreed. However, he remained absent in such proceedings. It is also observed that petitioner had pleaded that the firm of judgment debtor is not functioning and there is no office in the present address. I have carefully perused that address of the judgment is mentioned in all documents, including contract, arbitration proceeding, and present execution proceeding. As Mrs. Mello Enterprise so West Coming Arunachal Pradesh, and petitioner never intimated regarding the sense of their address. It is observed from the record the arbitrator has issued several notices on the address, and even executing court district and session judge Jeshpur has published the notice to the judgment debtor on 1/2/2023 through daily newspaper Arunachal Times, which is widely circulated in all districts of the Arunachal Pradesh, but petitioner judgment debtor remain absent. It is identically see that the petitioner judgment debtor has appeared before this court after issuance of the notice in same address. Hence, the plea of sense of address by the petitioner judgment are not acceptable.
This we have already read.
So and thereafter, this my lord, this paragraph page 118, my lord. It is further submitted learned counsel of judgment debtor putting a reliance of so and so. To conclude the point, on the basis of undisputed fact, objection under section 34 CPC filed against the arbiter is not maintainable as same is not a decree under section 2 to CPC. Further, arbitral award can be executed invoking 36 of the Arbitration Act. Along with the provision of CPC, same may be as manner as if it is a decree. In view of the above materials on the record, the legal position submitted by learned counsel of both parties, this court comes to finding the present proceeding under section 36 of Prohibition Council Act for enforcement of arbitral award and present application under section 47 is not maintainable. Accordingly, same is rejected. Paragraph 6, perusal of the record seen that the notice dated 30/10/2023, this judgment debtor asked to appear before this court and so shall not be executed at the suspension. So, my lord, here everything is given. My lord, from the Sonitpur district also, my lord, notice was issued. It was widely serviced, my lord. So far, some there's provision of the CPC itself speaks, my lord. CPC, my lord. When it was also reflected in order of the my lord, Sonitpur district court, my lord.
Okay.
I'm coming to that, my lord. My lord, PS 40, my lord, PS 40, my lord. Money acquisition case 5 of 2019. It was my in Sonitpur, it was 5 of 19, but subsequently it is 10, my lord, in Learned counsel for decreal present in terms of the last order 7/1/300 took step for causing service notice upon the judgment debtor as per order 5 rule 21A CPC and to substitute this fact submitted by affidavit which along with the copy of the newspaper Arunachal Pradesh published on witness the first paper to hand. I have seen the same and heard the counsel. And since in spite of the paper publication 1st February 2023 Indian Newspaper, which was widely published in newspaper, Arunachal Pradesh judgment debtor neither filed any petition either personally through the council or appear in the court today for filing objection. Given the conduct of the judgment, it transpired that the judgment is not willing to contest the case. And this part is important, madam. The seen the petition degree and the judgment debtor not choose to appear court to provide order 21 rule 3 judgment debtor is required to show cause as to why he shall put in civil prison or property shall be so and so. And my lord, so far, my lord, my lord, the substitution is concerned, my lord. Substitute proceeding is concerned, my lord. My lord, order 5 rule 22, my lord, of the CPC, my lord. My lord, here service substituted by an order of the court self is affixed as if it has been made in defendant personally, my lord.
Order, rule 22.
Order 5, rule 20.
Service within presidency terms. No, not this, this is not the one. Order 5.
Effect of subsequent service, my lord. Service substitute when the order of this court shall be effective as it has been made on the defendant.
Okay, this you are reading. 22. 20. Sub-rule 2. Effect of substituted service.
Yes, my lord. So, my lord, this was, my lord, the newspapers, it was there, my lord, in 2000, in Sonitpur itself. They not appeared, my lord. And thereafter, my lord, when, my lord, their petition, their application, my lord, is regarding section, the miss case 5, my lord. Miss case 5, your lordship may turn.
Page?
Page 81, my lord.
Okay. Yes, it's the one.
My lord, it is, my lord, paragraph 5, page 84, my lord. Before paragraph 4, my lord, they filed a requisition before the Honorable High Court, my lord, the regarding cancellation of their contract, my lord. The High Court says
Page 81 no? Of the main.
84, my lord. 84, my lord. This the miscellaneous petition starts, my lord, page 81, my lord.
Okay.
I'm 84, my lord.
84.
84, my lord. The 4, my lord, being agreed with the aforesaid action, a part of the respondent authority, but this one they cancel, they can take it, they terminate, contract was terminated, my lord, with risks and cost, my lord. The petitioner approached the Honorable Gauhati High Court by way of being WPC number so order dated so and so. The Honorable High Court was pleased to dismiss the said requisition inter alia that in view of the remedy available, the petitioner by your petition, the Honorable Court was not inclined to invoke discretionary power under section under Article 226 of Constitution in India. Next, my lord. Thereafter, for 9 years, there was no communication from the respondent, as the petitioner was shocked and surprised to receive a notice of money execution case on 30/10/2023. But before that, my lord, there is newspaper publication, my lord, from Sonitpur itself, my lord. Now they are saying that with a shock and surprise, my lord. From the Honorable District and Session Judge West Command District inter alia directing the petitioner to appear before the court without fail either personally or through authorized. Petitioner immediately made an inquiry, so and so, and copy of the record of money execution case, the certified copy of the records contain the Impian Award 93 received on 10/11/2023. According to the mail, they only 9 years they came to know the award was passed. But before that, my lord, the Sonitpur district several communication was made in arbitrator when it was proceeding was conducted, several notice issue. They have not received, it was returned. Ultimately, it was, my lord, without serving a notice, my lord, it was, or award was passed. It is fact, my lord. So, but there is a award is there, my lord. Award was passed, my lord. At this movie file execution case, my lord. Subsequently, it was transferred, my lord. So it is not a case, my lord, the first time, but they avoided, my lord. In my lord, section 47, my lord, this application, this order was passed. It was, my lord, categorically, and Sonitpur district also says, my lord, they avoided, my lord. Not, my lord, they is not aware of, my lord. My lord, thereafter, again, my lord, the lordship may press, press 86, my lord, paragraph 8. Upon receipt of the notice of the execution case and having obtained certified copy of the record of the execution case, which contains the arbitral award 19/3/2019, petitioner approached the state of the state council to challenge the award and proceeding as the same being initiated behind back and the proceedings as the same being initiated behind the back of the petitioner. But this is the allegation before against the advocate, my lord. But he was not the party respondent, my lord. I have placed one judgment of the Bombay High Court, my lord, in the record, my lord. My lord, mere my lord, making allegation, my lord, it will not do. This is the how they are good faith and a bona fide, my lord. All these things, my lord, it was not considered, my lord. In the context that the signed copy of the award was not never delivered to the petitioner as mandated section 30 of the arbitration and conciliation. Further, learned arbitrator proceeded ex parte through, though it is admitted the award, the notice was notice sent to the petitioner returned undelivered, and thus the same could not have been taken as service completed to proceed ex parte. But they, because my lord, it is true that they have not received, but they did not like at the time not to receive their notice, my lord. They avoided, they absconded, my lord. They never immediately after termination of the order of contract, my lord, they approach the High Court. High Court says that you go for the arbitration. They never approached. When the proceeding was started, notice was issued, they never received. And now they're saying that we have not received that. It was expert order like this, my lord. 9. Under the fact, the state of council advised the petitioner to file an application under section 47 of the CPC before the court inter alia, praying for dismissal of execution proceeding in the money execution, and further prayed for declaration of the award dated so and so as null and void. But the first portion, it is there, but they prayed for dismissal of the execution. And second, further praying for declaration of arbitration, it is not there in the application itself. So it is a wrong statement. It is said, petition was numbered so and so. The aforesaid application under 47 CPC was taken up for final consideration on 16/10/2024 by the Honorable Court, and Honorable Court dismissed the aforesaid application inter alia, holding that the other avenues for setting aside the expertise award for filing an application appeal and section 47 cannot be considered on the same footing as the application for expertise award or appeal appeal against the arbitral award. It is further observed that in view of the material on record and legal position submitted by learned counsel of both parties, the court arrived at the findings that the proceeding of execution of the arbitral award falls under section 36 arbitration and conciliation of 1996 as such proceeding in a section not maintainable and accordingly rejected. So, this is completely different. They came after the 36 petition, execution petition is pending. They insert their filing application. This is not a fresh application. So according to them, my lord, this, because of that, my lord, this said period, my lord, of section 30, section 47 petition which was pending and this rejected, that period is, they prayed for exclusion. But and honorable court also, my lord, they excluded that part, my lord. The judgment, my lord, the judgment, my lord, is already, the order is already in page 211, my lord. How the court, my lord, this passed the order. This, I'm reading from page 213, my lord, paragraph 3 of the order, my lord. Before it, before it 212 page, maybe lordship may
213, 212.
212, my lord. Because this is very important, my lord, this implement order, my lord. This is an application filed under section 34, 3 of arbitration 212, my lord. Read with section 14 of the Limits Act. The applicant is praying for condoning 280 days delay in up to 280 days in preparing application under section 34 of Arbitration Act, Conciliation Act to exclude the period from 16/12/2023 to 16/10/2000. It should be 2024, but it is 2014 written. Under section 14 Limitation Act, in preparing application under section 34 Arbitration and Conciliation Act 1996 for setting aside the arbitral award dated 19/3/2019. The facts narrated that the applicant is that the applicant who participated in the tender was awarded a work amounting so and so for construction prefabricated RCC wall and allied facilities in Misamari, Assam, which was supposed to be completed so on so and so. When the applicant for certain reason could not complete the award work within a stipulated period, the opposite party ordered 2021-2015 terminated the contract and also imposed a penalty of risks and costs upon the applicant. Applicant being aggrieved by the aforesaid action of the opposite party had approached the Gauhati High Court so and so. This already I read. The further state that the applicant for some years was shocked to receive the notice on 30/10/2023 issued by this court in money execution case number 10 of 2023 for his appearance on 16/12/2023. Accordingly, he applied a certificate copy of the case record money execution case so and so containing impugned arbitral award 19/3/2019 and received the same on 10/11/2023. He, on perusal of the same, came to know that an expert arbitral award dated 19/3/2019 passed by this sole arbiter without serving serving notice to him. The arbitral award award dated 19/3/2019, which was passed in favor of the opposite party, and opposite party was allowed to recover so and so with the cost so and so for execution from the applicant. The applicant further stated that the signed copy of the arbitral was never delivered to him as mandated under section 34(5) arbitration and conciliation. He, however, obtained certificate copy of the same on 10/11/2020 during the exam proceeding. Being aggrieved the expertise award, the applicant on 16/2023 moved an application before this court under section 47 of the CPC, praying for dismissal of the money execution case so and so for declaring arbitral award dated.
What do you have to say on this? That about the receipt which is contended, received the copy that he never received the copy.
My lord, the response
It was sent to him.
Yes, my lord. It was sent, but this long back, my lord, in 2019, my lord. But the only thing is, my lord, the court is, my lord, the exclusion part, my lord, whether it is rightly or wrong, my lord. Under section 14 of the Limitation Act, because it was completely attracted the case of the respondent, my lord. If it is attracted, then they have case, my lord. If it is not attracted, we submit that we have even when the arbitrary proceeding was there, my lord. It is there in record, my lord. They also, we have also next, my lord. There were several notice was served, my lord. Ultimately, they were not in there, my lord. So even my lord in Sonitpur district, with paper pollution is there, then they never appeared, my lord. And same address, same is they appeared in the Bomdila West Cameron, my lord. My lord, basically, my lord, this our written argument and written objection is there, my lord, but it was not reflected our objection in the order, my lord. Only this part was, my lord, it is there, my lord, in page 215, my lord. Learned counsel is so and so upon the party. On the other hand, fervently argued that section 14 Limits Act would not.
Which is para?
Para 9 at 215.
Good.
Learned counsel put so and so on the opposite party. On the other hand, have preferably argued that the section 14 Limits Act will not be applicable in the present case, as much as the relief sought for under section 47, which came to be dismissed by this court by order that 16/10/2023, which is completely different from the relief sought under section 34 of Arbitration and Conciliation Act. He further submitted that the relief sought under section 47, which came to be dismissed and under section 34 application for setting aside are completely different. This court cannot grant, this court can grant this application prepared under section 14 of the Limitation Act. But my written argument objection is in there, my lord. The whole submission was not recorded, my lord. Now, decision of this honor, the learned district judge. Upon carefully shifting through the judgment rendered the Honorable Supreme Court, Consolidated Engineering Enterprise and the versus Principal Secretary Irrigation Department, so and so, I have no hesitation to hold that the section 14 Limitation Act 1963 would be applicable in preparing, would be application under section 34 of the Constitution. We are not against, my lord. This is applicable. 14 is applicable. Our contention is that the in present case, my lord, it is not attracted. So
that is your contention.
Yes, my lord. This is our contention.
Not in principle, but in facts.
Yeah, but with this judgment, my lord, it clearly says, my lord, that the section 14 of the Limitation Act 1963 reached as the exclusion of time of proceeding bona fide with in the court without jurisdiction. Now this the question, my lord, bona fide, my lord, and my lord, diligence, this part, and my lord, they're completely the same issue, same there, my lord. In computing the period for any suit, the time during the plaintiff has been prosecuted with diligence and the another civil proceeding, whether in a court of first or of a appeal or revision against the defendant shall be excluded, which the proceeding relates to the same matter in issue and is prosecuted in good faith in a court which, from defect of jurisdiction and other course of like nature, is unable to entertain. To computing the period of limitation to any application, the time during which the applicant has been prosecuted with due diligence and other civil proceeding, whether in a court of first instance or appeal or revision against the same party and same relief shall be excluded, where such proceeding is proceeded in good faith in a court which, from the defect of jurisdiction on other cause of like nature, is unable to entertain. So third one is like CPC, it is not, we are not against that, my lord.
But I asked this question about notice because the period of limitation starts from the time of the notice, right? So the period of limitation under section 34(3), it starts from the
receiving the award. Receiving the award.
So therefore the executing person has to, I have to prove that the notice has been then the clock starts running.
My lord, order, my lord. According to this court, my lord, the learned district judge, my lord, the Bomdila, they, according to them, my lord, when they received the certified copy, my lord, They have received the certificate, redeem they received the award, my lord. Even that, my lord,
From there also it is barred
from there also, my lord, whether this, my
beyond the period of limitation.
yes, my lord, according to them, my lord, according to them, it is reflected there, my lord. This, my lord, they received the award, they received the award on 10/11/2023, my lord. The certificate copy from the court, my lord. From 10/11/2023, my lord, there is 90 days plus, my lord, these other 30 days, my lord. So here, my lord, the exclusion part comes, my lord, from the
10/11/2000.
10/11/2023, my lord.
Okay.
It was observed, my lord,
Yes.
this, the court below, my lord. So from, my lord, this only, my lord, the exclusion part, my lord, section 14 part, my lord. Section 40 part is as per, my lord, this, the judgment of the apex court or the judgment which was referred, this attracts in this case or not, my lord. And section 40. So for this, the award, my lord, even, my lord, this, what timing, my lord, it is received, my lord, according to them, my lord, according to court below, it is, my lord, from the said date, my lord, 10/11/2023. From counting, my lord, it should be in 90 days, my lord. So it was not necessary. They excluded the part, my lord, the application filed under section 47, that from the filings, from the date of, my lord, rejection, my lord. That part cannot be excluded, my lord.
So anyway, so I think we,
Yes,
I'm sorry, man.
my lord,
I'm sorry.
will you be able, I'm just, because I have some time constraint because I'm going tomorrow.
Madam.
Would you like to do it, keep it part and do it on Tuesday?
Part.
Tuesday. You are from Gauhati?
Yes.
We can do it in Gauhati
Yes.
on Tuesday.
Tuesday, my lord.
Or any day as per your convenience, because I didn't know that you are appearing for the other side. If some local council, then I would have
Yes,
to
yes.
subject him to the
No.
inconvenience of
No,
arguing through,
No,
online.
fine, my lord.
Both of-
We'll be glad if taken up, my lord.
All three of us are
Wednesday, my lord.
sitting, I'll be in the division bench, so you can get it listed. We'll get time in the second half, little bit.
12 तारीख.
Second half, my lord.
Lordship is sitting in a DB in the next week.
Yes.
Yeah.
So they can list it, but Tuesday I just mentioned as per your convenience.
12 Wednesday, my lord.
Take a convenient date next week.
Wednesday.
Wednesday, but
My lord, the second half, my lord, the lordship will also, my lord, from the division, so maybe free, my lord.
yeah, not hearing day, non-hearing day.
Not hearing them.
So maybe. So take it on Wednesday then.
Fine, my lord. Fine.
Because, my lord, this death proceeding is, my lord, the 34 proceeding is on 21st, my lord.
It's fine. It's 12 only.
Yes.
No.
And the court.
Now I have to carry this file.
Yes, my lord.
I have to carry, how will I carry it? You carry and give it there in the record. In the bench.
They will intimate I think, the bench, and accordingly it will be listed, my lord.
I will carry the file and give it to the section.
Yes.
Can you call?
Otherwise, we will sign it.
No need. I'm going tomorrow. I'll take it.
Because, my lord,
No need to send messenger. It'll be faster. I'm carrying it. I'm
Yes.
carrying other files also. So I'll carry this. also.
Yes.
my written argument is there, my lord.
Yes.
I placed 3 judgment. My senior panel also placed some judgment, my
Okay,
lord. Only final one judgment.
Not
should
my,
become-
my subject to what my lord brothers, my preliminary argument would be with regard to the maintainability of the writ petition, my lord. This CRP is not maintainable, my lord. There is a provision for appeal in section 37, my lord. So 226 doesn't come anywhere, my lord. 226 or 227, my lord.
I'll
We'll
try,
see that.
I'll try.
That is,
Satisfy that,
my lord. That would be my preliminary thing along with, my lord, other factuals, my lord.
Actually, I want to have good judgment from my lord, this issue, my lord.
No.
My lord.
It depends on the councils also.
Look, we are
Better
really
days.
glad the matter has been heard.
Better is the output.
On the last occasion, also, we came, both of us, came, my lord, the matter could not be taken up. We are glad that the matter has been taken up by your lordship, my lord.
So you were waiting also.
And
And I was worried because I had some time constraint, but the other council he has to do online. But since both of you are from there, so there's no.
No, it's absolutely fine, my
Yeah,
lord.
in
Wednesday,
case
we can.
It would have been completed today.
Yes, that's correct. my
That
lord.
was my concern actually.
Correct, my lord. Correct,
Otherwise,
absolutely.
Sometimes it is difficult to do full hearings on online.
No, that's true, my lord.
Sometimes.
It's difficult.
So
And
no
my-
problem. On
my-
Wednesday, we can do it.
Although my senior friend, although he's my in.
No, I am by name senior, my lord, but I am always his junior, my lord.
My lord,
I-
my lord, he will help the court, my lord.
In my eyes, all experienced counsels are senior.
Yes, correct, my lord. That's the correct, my lord, proposition.
12.
Heard is very learned counsel for the CGC, right? You're
Yes, CGC.
as CGC for the petitioner who addresses some arguments and length. However, the same arguments of the petitioner side remain inconclusive. The matter will be kept as part of list on 12/8/2026 in the hearing column. It has come up in the hearing column. Learned counsels. So
HK Das, my lord.
and
Yes.
get asked for assistant. You are also your name.
NK Sharma, NK Sharma, my lord.
Sharma, for the respondent, sole respondent. Okay, these are interesting matters also.
Yes.
Yes.
Arbitrary, commercial, and these
Yes.
are very important.
Arbitration matters are always in.
These are
And actually, so that
Lordship has kept the part as
Civil
part.
just part of it.
Yes, fine.
Actually, so I try to take an answer from this.
So many judgments are coming. This actually now.
Yes, my lord.
Arbitration.
Yes.
Okay.
Highly appreciate.
Much.